can I add something to that, which is that one of the purposes behind the 2004 Act, when the whole system of HMO regulation was, I mean, it existed beforehand on a voluntary basis, but obviously it was made a lot stronger. One of the purposes of that Act was that it was supposed to be a self-funding system, self-funding scheme. Local authorities can charge quite a lot of money for an HMO license, and that is supposed to then fund the regulation of the HMO scheme. Now, HMOs are one of the most dangerous sort of sectors of our housing, but it's not only about housing conditions, it's also about being a physical person, management of the property, and so on. So if I was working for a local authority, I would want to be thinking about increasing the HMO regulation scheme because it is self-funding, and because it actually, it's not just the funding, it's also the fact that then the local authority has the information that they need in order to regulate, as I say, one of the most dangerous sorts of housing. So, for example, in Lewisham, there is a selective licensing system, which means that all flats above shops have to be licensed, and that's because flats above shops are dangerous and have some of the worst housing conditions. So, I mean, it's definitely political rather than legal, but that system, to say, is supposed to work for local authorities. Yeah,
so often they get the awards, but they don't get the money. Whereas Camden, who we work with, are just a real inspiration from a Rogue Landlord perspective. They concentrate on getting the awards and getting the money, and they've got about £1 million. And off the back of that, they've taken us on. They've got their own solicitor embedded in the team. They're not even in the legal team. They've just taken on 2 trading standards officers to start proactively targeting letting agents. That's the model. That's a really inspiring thing. That's the way everyone's got to go.
Yes. Got to wait for I've got a microphone waiting now.
Hello. Whoa. If anything too well, go easy.
Sorry. Hi, my name's Karen Jones. I work at Islington Law Centre as a housing solicitor. This is a question for Ben. I'm quite intrigued about, you said that in terms of the renters' rights bill, they're going to be introducing, let me just get it for you. Sorry. I just wanted to know a bit more about it. Yeah, you said that the renters' rights bill would introduce the equivalent powers for persons accompanying council officers. I just wondered, I know that that would apply to someone like yourself who has a lot of knowledge about housing rights, but in Islington, there's lots of support workers that may work with vulnerable clients before they come to us. And I was just wondering whether that would apply to them, because under some of the work that I do, I also work on a project called the 3 Advise Project, where we provide training to support workers in the borough. So I'm just wondering whether that's something that would apply to them as well.
So when that one came in, it took us by surprise, and we called it the safer renting bill, because it was almost like the renting for us. That's great. So I run Renata, who's one of the steps up to put it together. I said, I can only see that being useful to us. So who else would it work for? Right. And she said, yes, to do with the investigatory powers. So there's these new investigatory powers that you can demand documents and stuff like that. And if you're a person who goes into the property, you have to be accompanied by a spoken to the local authority. Yes. And then with your charge, you have the same powers, investigatory powers as that person, as long as you're using it under the supervision of a designated officer as well, which is kind of how we work anyway. But because it relates to the same powers, I can't see how that would apply to the scenario you're saying. Right. You shouldn't be looking at it in that kind of way. But you could go with them. There's no reason why you couldn't accompany. And if you go under warrant, you can accompany under warrant as well. Many people do, you just wouldn't have any powers from them.
Right. Okay, thank you.
Any other questions? Oh, sorry. Oh, hi, sorry.
Thanks. So I'm from Tower Hamlets Law Centre, and obviously in Tower Hamlets, as we've seen with Mohammed Haq, there's a lot of criminal landlord activity. One of the issues that we find is that criminal landlords know how to move assets to prevent enforcement of, let's say damages or an RRO. And so, for example, one case that we have is where a landlord, the tenant's entered a contract with someone who says they're the landlord, they own the property that the client's living in, and then their managing agent is effectively the landlord carrying out harassment and refusing to do repairs, trying to terrorize the tenants, but the managing agent, who is in effect the landlord, has made sure that they have no assets themselves that we can target for costs and damages purposes. So I don't know whether there's an effective way of trying to target the people around them who own those assets, or whether we have to kind of limit ourselves, and whether there's other things that we can do to target them appropriately, if that makes sense.
I would say, so a couple of the sessions later, I think are going to be addressing that. So moving forward is going to be talking about some of the sorts of situations that you were talking about are exactly the sort of situations we might find out who exactly owns property, when exactly so on, what exactly is the other relationship, so on. So his talk might address some of your questions on that. And then John Hobson is going to be talking about enforcement, which again sometimes raises similar sorts of issues, obtaining information, getting parking orders, and dealing with enforcement in that sort of way. But in terms of the liability of third parties, I mean, it depends on the offence that you're talking about. Really, some of them have to be committed by a landlord. Some of them can be committed by somebody else. So, for example, harassment, the landlord. Eviction from Eviction Act does need to be the landlord. I have no doubt that if you have an individual who is behaving badly, that there is something that you can attach to them. It just might be different from what you could attach to a landlord. I'm not sure if that was a terribly good answer, but probably as good as I can do right now.
Well, I just think it's the criminal orders is the one I'm thinking of. Rent-to-rent scamming is an epidemic, and we've already stopped doing them simply because everyone that targets the immediate landlord is always a dodgy company with no assets. And Rackison and Jepson, we were the interveners in Court of Appeal and Supreme Court and lost roundly. I was really pleased when it's come back in with the RRB. So now we're going to start doing it again, we should go after the asset holder. And the whole premise of rent-to-rent, guaranteed rent, is how to make money from property without owning property. Therein it lies. If you haven't got the asset, you're never going to get your money no matter what you do.
Thanks, everyone. This is our panel session on harassment and unlawful eviction claims. I've got two announcements first. One is that we're going to send around the PDFs of the slides afterwards if people don't already have access to them. There's also 20% off lag books outside, so go check that out if you want to get some books. My third announcement was going to be that Gus was running late, but mercifully he has got here on time. We have today three great speakers. Two are from Doughty Street. We've got Alice Irving on my left and Daniel Clark on my right. Alice is going to be talking to us about the types of civil claims that arise out of unlawful eviction situations. So an overview of the legal principles and the types of claims you might want to bring. Dan is then going to talk us through the various and sometimes conflicting approaches of the courts to quantifying damages for unlawful evictions. And finally, we have Gus Silverman, who is head of DPG's very well-respected Actions Against the Police team, Bristol. He has particular expertise in the police's positive duties under the Human Rights Act, and he's going to talk to us about how you can use human rights obligations to force the police to perform their duty to protect people against unlawful evictions. So first off, Alice.
Right, I feel like the presentations are going to get progressively more interesting. So you'll have to bear with me if I'm giving you some of the 101. I'm sure that a lot of you are already familiar with what I'm going to be covering today. So I'm just going to do a quick trot through the different types of civil claims you might be looking at bringing or thinking about in circumstances where your client has either been unlawfully evicted or threatened with unlawful eviction. And as I'm sure a lot of you are already aware, there isn't a tort, for example, called unlawful eviction per se. And so you're going to be wanting to kind of thread together a range of different civil claims and making sure that when that's pled or put forward in a pre-action letter, if that's the kind of situation you're in, that you're ticking all the boxes in terms of making sure you're hitting all the elements. I think it's quite easy sometimes to kind of forget to work through all of this systematically. And so I hope that this is a useful kind of crash course. The list of claims that you'll be thinking about, obviously trespass to land. We've got breach of contract or covenants that are going to be implied into most tenancies. We've got the Protection from Harassment Act, which creates a civil claim, a statutory tort. And then we've got the specific Housing Act action that you can bring, which is in respect of loss of the right to occupy. And that can have some interesting consequences in terms of the quantum that you can obtain. And Dan will speak to that. And so that's something you're going to want to be thinking about as to whether it's worth doing that or not. The final Protection from Eviction Act is in brackets because I think there's some real doubt around how useful that is, but it's always worth turning your mind to whether or not you want to think about that. And then finally, sort of a catch-all there, a list of other things you might want to be thinking about. I'll admit that when I get a case like this, I'll often just get Barkin and Still and Torts open and work my way through the kind of list of things and go, are any of these going to be applicable? And I think it's a good discipline to make sure that you don't miss any kind of potential angle for your client to do that. So trespass, as I say, sorry if this is 101, you're going to need a right of exclusive possession to be able to bring the claim. And obviously, if you've got a tenant, that's going to be pretty straightforward. If you've got a licensee, it's more complicated. A licensee could bring a trespass claim against somebody that wasn't the licensor, but they don't have a right of exclusive possession relative to the licensor. So this is going to be much less useful in that kind of context. We're talking about any kind of unjustifiable intrusion, and it can be tiny intrusion. It doesn't have to be anything really major or dramatic, but it does need to be direct. So, for example, if somebody arranges for the electricity to be stopped, but that doesn't in any way involve going onto the land and the property or touching anything, that's not going to be a trespass, although it will be covered by something else. So just make sure that you're thinking about that when you're pleading it, and you're thinking about, or setting it out again in a pre-action letter, you're thinking about what is the interference actually that we're alleging. There is no requirement for damage, it's actionable per se, so you don't need to show any kind of impact whatsoever, although obviously when you're thinking about making a claim for damages, you're going to be wanting to set out the impact anyway, because it's going to help you to kind of make the case for a higher quantum. There are instances in which somebody will be obviously justified in entering property, and that includes where somebody's given notice and they're coming to do the repairs, or notice to come and view and inspect the property. Those are implied into tenancy agreements that people have a right to enter to do that. But I think really importantly, keep an eye on the kind of breadth of that implied right. So a landlord, this is a bit close to home actually, because my landlord tried to do this to me recently, where they're like, we're going to come in and do a whole bunch of improvements. And that was like super disruptive, that went far beyond repairing obligations. And I was like, actually, not sure you are going to do that. So if you've got works that are ongoing in a way that's incredibly disruptive, and those works are much more disruptive than they ought to be, that could be a trespass. So don't just assume because they're there doing repairs or something else that it means that they're justified to be there. And again, if there's not adequate notice, obviously, I mean, you all know that they can't just turn up. Another favorite of my landlord. It's all a bit close to home sometimes. So that's trespass. It's pretty straightforward, but make sure you hit all of those elements. I think it's unfortunate sometimes that we see cases come in maybe later on, and you can see that the bits of it haven't really been particularized properly, sometimes in pleadings and so on. And so you just want to make sure you're being really systematic. Breach of contract. Oh, before I move on to this, one of the reasons you want something like trespass in is because the tort opens the gate for, and I'm sure Dan will talk about this, aggravated and exemplary damages, which you're not going to necessarily be able to get in the breach of contract context. So that's another reason why you want to make sure you're covering all your bases and pleading all of the causes of action systematically. Breach of contract, as you all know, implied into every tenancy, covenants not to interfere with quiet enjoyment or to derogate from grants. Those are not exactly the same thing, but they're pretty much coterminous at this point, so that I don't think there's much to be gained from thinking about those separately, although you might want to set both of them out just to cover the bases in any kind of pleading or pre-action letter. Again, licensees might be in a trickier position. If you've got a contractual license, in certain circumstances, there might be an implication of a covenant of this sort, but often because license can be revoked on reasonable notice and so on, it's going to be difficult to use a breach of contract claim. And it's not going to be every contractual license that will have an implied term either. It's going to be very fact specific, but don't, again, just do have a think about it if you happen to have a licensee. The benefit of breach of contract is that we've got direct interference like trespass, but also indirect interference. So cutting of utilities, banging lots on the walls, for example, if a landlord has access to a neighbouring property, and all of the kind of things that we know landlords sometimes do to try to make people leave, can be a breach of the covenant. You do, however, because we're in contract law, this is very much like second year law school, need to show damage. And again, it's really important that you particularize that, and it's not a context in which mental distress falling short of an actual sort of diagnosable condition or personal injury will suffice. But there's a slightly odd quirk where if there's been a physical inconvenience that then has caused mental suffering, you can then plead that. So if you've got somebody who's like, oh, well, you know, the noise is keeping me up at night all the time. I'm not sure that's a good example. Cutting off utilities. I'm really cold. I'm very physically uncomfortable, and that's caused distress. So that's the kind of thing you can tease out. Although the reality is that because you're often pleading all of these kind of in parallel with each other, you're going to be able to kind of pick up all of the different types of impact on your client by kind of linking these various claims together. So the Protection from Harassment Act 1997, this is where we get beyond first year law sort of mercifully, this prohibits a course of conduct which amounts to harassment of another, where the person who's carrying out that harassment knows or ought to know that it would amount to harassment. So it's not about what a person intends to do, it's enough if they ought to know that it would be harassment. And what's interesting about the Protection from Harassment Act is that that's the same prohibition that underpins both a criminal offence and a statutory tort. And I'll go on in a second to talk about why that's important when thinking about whether you've hit the threshold for harassment. There are some circumstances in which something isn't harassment, which is preventing, detecting crime, doing something under an enactment or a rule of law, and if the course of conduct is reasonable. To be honest, the kind of cases we see, I've never had a case where I've thought there was any possibility of that being raised as a response to a potential claim. And it's Section 3, as I say, that creates the statutory tort. And the benefit here is that you can plead pure anxiety or distress without something amounting to personal injury, as well as financial loss resulting from the harassment. There isn't a statutory definition of harassment, but we can piece together what it means from various sort of bits of definitions elsewhere in the legislation paired with what the case law has said. So we're talking about causing somebody alarm or distress. And I was talking to Sarah just before, and she was pointing out that one of the things that's really interesting about harassment is that you don't necessarily need to be aware at the time that the conduct is going on. You can find out about it later. And if that causes you alarm and distress later, that can be sufficient. So that might be a case where somebody is being tracked or stalked, for example, potentially by a landlord, and they're not aware at the time, but they are subsequently become aware of it. That's not going to stop it from being harassment. You need a course of conduct. So you need at least 2 instances. I've not elaborated, but in the legislation, there's a bit more that sets out where you've got maybe more than one person involved in the course of conduct and how you figure that out. And there's some flexibility around that. But normally you're looking for something that's more than a one-off, or you definitely need something that's more than a one-off. And the conduct can include speech. So it doesn't have to be just actions. The House of Lords decision I've cited at the end there is often the touchstone, and you can see that it's going to be very evaluative, but we're not talking about everyday annoyance, people being even unreasonable. It's got to be oppressive and unacceptable. And the point that I made earlier about the fact that the prohibition on harassment in this legislation unpins both a criminal offence and a statutory tort comes into play here, because what the courts have basically said is, well, because this course of conduct could be both a crime and a tort, we need to be thinking, well, is this really bad enough to hit the criminal threshold of behaviour? And I think that's quite a useful yardstick in thinking, because I think often we do have clients who say, I feel like I'm really being harassed by my landlord and it's horrendous. And there can be some expectation management, I think, sometimes around this about the kind of thresholds we're actually having to hit. And this can be a useful way of trying sort of explaining sometimes, although often then people go, they might say, oh, well, it is criminal. Let's, so just obviously in your client management, you want to be thinking about how you navigate that. But we are looking at something that would sustain criminal liability in terms of the severity of the conduct in question. So some examples. The first case is in a commercial context, and I'll just refer to it in passing. But when we're talking about a large volume of sinister emails, alarming emails, anonymous threatening phone calls, I think the emails in that case were often copied into everybody and their uncle. That can amount to a course of conduct leading to harassment, and we do see that obviously from landlords. Worthington is a really interesting case and really helpful actually in lots of ways. So that was a claim that was brought by a housing association tenant who she initially basically was concerned about antisocial behaviour in her area, and she'd set up some CCTV and was also sort of recording behaviour. And some other people locally complained about that being intrusive. And the housing association, as they want to do, took a side without really thinking about it and without really looking into whether there was sort of a basis for the complaints against her, started sending some really threatening legal letters saying, we're going to seek an injunction, we're going to take legal action against you. And it was really sustained. Eventually, they conceded that there was no basis for that and she hadn't breached her tenancy in any way. She brought the action and successfully established that that had amounted to harassment. So that's a really interesting one to think about, where we're not talking about the kind of classic circumstances of somebody just trying to force someone out, but we're talking maybe about somebody that's more of an institutional actor, but they're really not engaging their brains and thinking about how to deal with a neighbour dispute. That might cross the line into harassment, so it's worth thinking about. The final case there's an article up online because it was a couple of colleagues here in Doughty Street who were involved in that case. And I think it's interesting for a couple of reasons. So you'll see a précis there of the kind of conduct, which again, I'm sure, unfortunately, we're all fairly familiar with in terms of the kind of pressure and behaviour that can be involved in trying to get somebody to move out. And protection from harassment was found. But in addition, there were successful claims for direct discrimination and Equality Act harassment. And I just wanted to flag that. Now, it's not obviously every case where we've got this kind of conduct that you might be thinking about looping in the Equality Act. In this case, some of the comments that were made by the landlord opened the door to that being a possibility. And so you see some fairly offensive comments there about the tenant being a foreigner. And that was enough to raise the prospect of direct discrimination in terms of unfavourable treatment linked to a protected characteristic. So you're always going to be wanting to think, is there a hook that gets us a protected characteristic? That then shifted the burden of proof under the Equality Act to the landlord to show that it wasn't to do with race. And I understand from talking to colleagues that the landlord didn't do himself any favours under cross-examination, and so that was made out. And similarly, harassment. So you've got the kind of conduct that creates an environment that qualifies under the Equality Act. So sort of hostile environment is, I'm not going to set out the whole legislation, you'll see it in section 26, but again, that needs to be related to a protected characteristic. But if you have something that looks like it might be racist, ableist, something like that, you might want to think about including that as well, because it's a way, again, of ratcheting up the kind of stakes and potentially the quantum. And the outcome of that case was fairly significant. I think it was about 50K in the end of damages that were recovered for a whole course of conduct. And there, the direct discrimination and harassment under the Equality Act covered everything in terms of trying to get them out, trying to get them to sign off on increased rent, as well as the kind of conduct, the swearing and all of that kind of stuff. Sorry, I know we good? Okay. Right, so Protection from Harassment Act, definitely think about it. The Housing Act 1988, this is applicable where somebody has actually left the property. So this isn't going to be useful in cases where there's a course of conduct, but it hasn't actually resulted in either somebody being forcibly evicted, whether that's change of locks or similar, or where somebody has withstood the kind of pressure and has remained in the property. But as you can see here on the slide, the kind of first circumstances in which this legislation will apply is where somebody unlawfully deprives a residential occupier of occupation. And then the second is, sorry, it's lots of ors and ands, but where they try to do that, or they do things that are likely to cause the person from basically using the property. So that's the kind of thing where we're talking about cutting utilities, making lots of noise, being deeply unpleasant. And those, acts interfere with their peace and comfort. And as a result, the residential occupier does give up occupation. I think it's really easy to start reading section 27.2 and go, they've attempted to unlawfully deprive. This is, I can get them for attempt even though they've not left, but keep reading. At the end, the person actually does have to have left as a result of that conduct. So you might be under 27.1 where it's more straightforward. They've changed the locks. 27.2 is the kind of conduct that results in a person leaving territory. Where the section applies, what you can get damages for is the loss of the right to occupy. So obviously that's different to example, the kind of distress measure of damages that we were talking about in respect of some of the other actions we've covered. And that's why this is important. And I know Dan will cover this when he talks about quantum. Section 28 tells us how quantum is assessed in this context. And it's always worth thinking about. It will depend on sort of the security of tenure that a person has. This could potentially be worth a lot of money. And that's why you want to be thinking about whether you want to bring a Housing Act claim of this sort. But there are a few important caveats. If a person has been reinstated to the property, either because the landlord's seen the light or more likely because there's been a court order, an injunction requiring them to let them back in, you no longer have loss of a right to occupy, and so you don't have a claim. You've also got a couple of defences that are worth thinking about. So reasonable belief that somebody had ceased to occupy, or they've done something that's reasonable, so they've withdrawn services in circumstances where it's reasonable. Really important as well that damages can be reduced because of the conduct of the tenant prior to the unlawful eviction. And landlords love to float this kind of stuff in a very vague, unparticularized way. So I would say if you've got a case where you're thinking about running this, you're going to want to take very clear instructions and probe sensitively initially whether there's going to be any basis to any of that. And if a landlord runs the point, you're going to want to be pointing out that it's got to be properly particularized. And if they've not pled it, they shouldn't just be turning up at a final hearing and waving their hands around and saying, well, my tenant was terrible, I'm allowed to do this. This is a whirlwind tour. Protection from Eviction Act, Section 3. So there's a prohibition, basically, of recovering possession without, a court order. We know that's illegal. But this only applies to things that are not a statutorily protected tenancy or an excluded tenancy. And you'll see further down the slide there that an assured tenancy under Part 1 of the Housing Act is a statutorily protected tenancy. So our bread and butter, often assured tenancy cases, this is not going to help. It won't apply. Interestingly, this can apply to licenses as long as they're not excluded licenses. So whenever I have a case that's not an assured tenancy, particularly if it's a license and I'm thinking, is there anything I can do? I'll pull up the legislation, I'll work my way through every time through the definition of statutorily protected tenancy, through the definition of excluded tenancies or licenses, and just check. I don't hold it all in my head because it's really technical, but just do the check in the primary legislation. The other slight wrinkle that we have is that there was a recent, relatively recent, it's always alarming when you say recent and then you look at it and it's 3 years ago, Court of Appeal decision where there was a passing over to statement saying, oh, we don't think this gives rise to a statutory tort. So there's a real question mark actually around what you can do with this. But if you go on Nearly Legal, you'll see that Giles has had a fairly understandable rant about why he thinks that's wrong. And it is an over to statement. So it's still sort of worth thinking about. But in practice, I've never actually found a case where it seemed worth using this. But I always, as I say, with a case like this, just work systematically through all the potential causes of action, go yes, no, to make sure I'm not missing any potential angle, any potential way to push up the quantum that my client might be able to recover, which is a nice moment to hand on to Dan to talk about how to calculate that quantum.
Thanks very much, Alice. So I've focused in this on damages since the Court of Appeal decision in Smith and Carn, and like Alice, I was horrified when I was going to call this something like recent developments, and I noticed that it's actually 7 years ago now, Smith and Carn. But having said that, it seems to me to have raised a number of questions which still haven't been dealt with in any authoritative case law since then. And certainly speaking for myself, I find that it's still a matter in doing cases of trying to work out how the implications follow through in cases on different facts. I'll certainly be very interested to hear other people's experiences. I'll talk about one case in particular that I've done, which it actually is recently. It was this year. But yeah, certainly it's without higher court case law, it's very important for us to be sharing our experiences of what we've been running, what works, etc. So starting with a recap on Smith and Carn. Court of Appeal decision in 2018. The facts briefly were 30th of June 2014, Mr. Carn grants a 12-month assured short-hold tenancy to, in fact, to Mr. Smith, the claimant's husband. The following March, during the fixed term of the tenancy, Mr. Smith moved to Scotland while Mrs. Smith remained at the property, and so she was occupying, fulfilling the condition, the tenant condition, in his stead. Then the following month, Mr. Carn changed the locks to the property, and Mrs. Smith obtained an injunction for reinstatement, but subsequently learned that the property had been relet and there was another tenant in it. So in late June of that year, around the time of the end of the fixed term tenancy, Mrs. Smith hadn't sought to enforce her injunction for reinstatement, and she collected her belongings from Mr. Carn. And the Court of Appeal, there was a first instance decision by a district judge, which was then appealed to a circuit judge. And on the second appeal, the Court of Appeal came to consider the approach that should be taken to damages in trespass in a case of unlawful eviction. And so the first and really key point that was made, paragraph 37 of the court's judgment, was that damages are payable for the period during which the claimant's right to possession subsists. And the court said at 37 to 38 that where you have a case where the tenant is reinstated, damages continue to that date, i.e. for the period of exclusion. But that if the tenant abandons the claim for reinstatement, the issue is more difficult. And that's effectively what had happened in Smith and Carn. So looking at how the issue should be determined on the facts of that particular case, the court said at 39, again repeating a similar point, the question is not how long that it would have taken to obtain possession lawfully, which I think is effectively the approach which people had been happily taking for many years up to this point. And they said it's actually the question of how long the tenant's right of occupation in fact continued. And so then working it through on the facts of the particular case, they said after the 30th of June, so after the expiry of the 12-month fixed term, Mrs. Smith's right to remain in the property would have depended on a statutory periodic tenancy arising under Section 5(2) of the Housing Act 1988. And that in turn depended on the tenancy having remained an assured tenancy, an assured short hold tenancy at that date. And so on Mrs. Smith having occupied the property as her only or principal home at that date. Now, on the one hand, the court said the landlord can't rely on the fact that he'd unlawfully excluded her from the property to say, well, look, she's ceased occupation and therefore it's not assured and therefore no statutory periodic tenancy arises. But the court said the position changed once she elected not to pursue her right of reinstatement. So once she decided not to enforce the order, it couldn't sensibly be said that her occupation continued. And therefore, certainly by the 30th of June, she was not occupying, therefore the tenancy wasn't assured and no statutory periodic tenancy arose. So her right to occupy the property ceased. And so that was how they came to the appropriate period, the end point for the period for which damages would be awarded. And that's, that's the point which I think really has raised lots of questions, which I'll come to in a moment. The court also looked at the rate of damages that should be awarded for that period. And it made there was an argument made on behalf of the landlord that damages shouldn't exceed the equivalent nightly rent because that's all that the tenant was being denied. And the court said that's not right because in unlawful eviction cases, damages compensate not only for the letting value, but also for the anxiety, the inconvenience and mental stress involved in the loss of what was the tenant's home. And the court said that a summary of recent county court decisions indicated a range of £100 to £300 a night, and that it was appropriate to take into account those previous awards. So moving from the decision Smith and Khan itself, just finishing off on the kind of the position as it stood at that stage. First of all, I think it's right to say that even at that stage, the range of 100 to 300 wasn't perhaps the full range that one saw from the county court decisions. And in fact, when one looks at the decisions in, for example, the housing updates in Legal Action magazine, you can see that two things. First of all, the awards tend to depend on the particular circumstances of the eviction, and that is perhaps an obvious point, that where one is compensating for anxiety, distress, etc., it's going to depend a lot on what your circumstances are, particularly what other accommodation, if any, was available during the period of exclusion. And the other point I think it's fair to note is that awards tend to taper, the nightly rate tends to be tapered as the period gets longer. So for very short periods, you might get a higher nightly rate, and then for very long periods, you get a smaller nightly rate, but obviously a higher overall award. And that, it seems to me, is a sensible approach in the sense that the initial shock of the eviction means that that initial period might be the worst in terms of its effect on the tenant. And then as time goes on, that initial shock subsides, and also they're likely to settle into some alternative situation. So I've put a table there giving an indication just on the basis of the awards that I've looked at of three situations: street homelessness, sharing with friends or family, and accommodation, independent accommodation alone, for example, temporary accommodation under Part 7. That's in order of descending order of value in terms of a nightly rate, and I've given an example of a lower award and a higher award. So you'll see there for street homelessness, and these figures I've uprated for both the 10% uplift in general damages under Simmons and Castle, and for inflation. Street homelessness tends to give a range of between 215 for a long period, 65 nights in Hunt and Hussein, to £575 a night for 7 nights in Ogie and Bundu. Sharing with friends and family a bit lower, 158 to 516, and then accommodation alone, you'll see actually in Lopez and Singh, there was an award of just £38 a night, uprated equivalent, but that was for almost 3 months, up to almost £300 a night in Hussein and Mir, where it was 14 nights in a hostel. So a bit more to the range of nightly values than the court's summary discloses in Smith and Carn. The other point to make about trespass damages is in relation to aggravated and exemplary damages. Just by way of very quick recap, aggravated and exemplary damages are available in tort but not contract. So going back to Alice's summary of the causes of action, one of the big advantages of a trespass claim over a breach of quiet enjoyment claim is that you can then be looking at aggravated and exemplary damages. Aggravated damages are there to compensate where basic damages would be insufficient to compensate the injury suffered. So where there are particular features of the case that meant that the basic damages wouldn't cover or wouldn't adequately compensate the tenant. Exemplary damages, on the other hand, are there to punish the landlord, to deter future conduct of that sort, and to prevent a landlord profiting from unlawful eviction. And it's fair to say that courts will usually, although not quite always, make awards of aggravated and exemplary damages in unlawful eviction cases. There's the old Court of Appeal authority of Drain and Evangeli, which talks about unlawful eviction being one of the worst torts that can be committed, and therefore it's justified that exemplary damages should be awarded. Most of the awards have tended to be moderate, so between about £1,000 and £5,000 on a kind of on a uprated basis. I have thought for quite some time, though, that there are good arguments that awards should be higher, particularly given the profits that are available to landlords in the private sector. Those kind of figures aren't really going to act as a sufficient deterrent. And there are certainly some examples of the courts being willing to make higher awards of aggravated and exemplary damages. So I've cited a few there, and you can see in the Meta case, and these are all uprated figures, 18,000 in aggravated damages and 13 in exemplary. Daly and Mahmood, there was 27 and 50, but that was split between 4 claimants. Abbas and Iqbal, 15 and 11, and Kashmir and Walsh, 15,000 in aggravated damages against each of 3 defendants, albeit that there was no exemplary damages awarded. So that's certainly something where I think people should still be pushing and trying to justify higher awards. Moving on then to look at developments since Carn and the issues that arise from it. The first point to make is that old habits seem to die hard. So there were at least 2 cases I found post Smith and Carn where the court seemed to still be taking the approach of working out how long it would have taken lawfully to evict the tenant, which on my reading of Smith and Carn is not the correct approach. So Albu Swalin and Regency UK Limited, the first instance decision is reported on Nearly Legal, and it seems that the parties agreed that damages should be awarded for 60 nights on the basis that that was the minimum period of Section 21 notice, and that agreed position was accepted by the judge at first instance. And then there was an appeal on a different point, which was dismissed by Mr. Justice Chamberlain. And then similarly, in the case of Sanchez and Simple Properties, the legal action report talks about damages having been awarded for 90 days being the time in which it would have been possible lawfully to end the tenancy. So it certainly doesn't seem that Smith and Carn has effectively killed off that line of argument even being accepted by judges. But my view would be that isn't the correct approach. The difficulties, a number of problems presented by the approach set out in Smith and Carn. The first is that it produces slightly arbitrary distinctions in how much tenants get. I suppose on the rationale set out by the Court of Appeal, it's not an arbitrary distinction, it's a distinction based on a different principle. But you can see how a tenant who's evicted much later in a fixed term will end up if they then abandon a claim for reinstatement like Mrs. Smith did, will end up getting a very short period of damages as compared with somebody evicted earlier on in the fixed term, even though for both of them they might have suffered the effects for 2 months or 3 months or however long it might be. And so there's a potential unfairness there, or you can end up with people getting very small awards which aren't justified. And there's a particular problem which arises from the fact that in that kind of situation, the focus is on a claim for reinstatement. Because as we saw from Smith and Khan, what stopped her damages continuing beyond the end of the fixed term was that she had abandoned her claim for reinstatement, and therefore the tenancy was held to have come to an end. But there is a risk, I think, that approach will end up rewarding landlords whose conduct is worse, either because they cynically act very quickly to relet the property to defeat a claim for reinstatement, and so the tenant abandons it because there's no point, or because the landlord has been so awful that the tenant can't contemplate moving back in there at all. Those landlords would end up with the damages being cut short, whereas a landlord who had perhaps mistakenly but honestly believing that they were entitled to evicted the tenant, and then a claim for reinstatement had taken some time and got them back in, would end up with a longer period of damages. It also, I think, potentially creates a situation where a tenant is pushed into or pushed towards the idea of pursuing a claim for reinstatement despite not really wanting to move back into the property, just because that's the way to extend or not to lose the period of damages. And in fact, it would be quite difficult, I think, for the courts to determine when a claim for reinstatement was being pursued solely for that basis. So a tenant might decide tactically to include his claim for reinstatement, not pursue it very urgently, and then at a later stage abandon the claim and say, oh, well, actually, I didn't abandon my claim until, 2 years down the line, and therefore I'm entitled to 2 years worth of damages. It's not quite clear to me. I suppose there'd be a matter of fact for the court about whether that was being seriously pursued. And so one of the examples that I found in recent cases, the case of Tahir and Agri, you ended up in a situation where, in fact, no award was made for unlawful eviction. So there was an award for harassment made, but because the tenant returned the keys to the landlord, they ended up not having a period of nightly damages for unlawful eviction at all. So those are some of the issues. The other issue, which I'm going to come on to discuss now in relation to a specific case that I was involved with, is the difficulty in identifying an endpoint in cases which don't fit the kind of Smith and Khan factual circumstances. So I'm going to talk now about a case of Venton and Zach Williams, which was reported in the Legal Action Housing Update a month or two ago. It's worth setting out the facts, partly so I can discuss them, but also partly because the report, some of the facts are not quite accurately reflected in the report that ended up in Legal Action. So it's worth setting them out so that when you see it, you have that in mind. This is a case on the 14th of January 2020. The landlord granted the tenant a 12-month express periodic tenancy, so a tenancy from year to year. Towards the end of that first year of the tenancy, the landlord, following a missed rent payment, started harassing the tenant and seeking to unlawfully evict her. And then in January 2021, so just before the end of the first year of the tenancy, the landlord moved into the spare room in the property, removed the locks on the property, started to fit locks on internal doors. Really quite serious harassment, trying to force the tenant from the property. During that time, the landlord took no steps actually to serve notice to end the tenancy at the end of the first year. So on the 14th of January 2021, a new 12-month period of the tenancy arose. The solicitors for the tenant sent a letter before claim warning the landlord about his conduct, but that didn't change things. And in fact, immediately after that, the tenant was admitted to hospital in a mental health crisis and was subsequently advised by the mental health practitioners not to return to the property for the sake of her mental health, and she was accommodated in accommodation under Part 7 of the Housing Act. In August 2022, so quite some time after, she was provided, the local authority secured her an alternative private sector tenancy in discharge of their Part 7 duties. Then in another year later, following further letters for claim, the tenant issued a claim and default judgment was entered. The question that arose in formulating that claim was what period of damages were going to be claimed. We had an express periodic tenancy, so the continuation of the tenancy wasn't dependent on Section 5 of the Housing Act. And in theory, although she would lose security of tenure if she wasn't occupying the property as her only or principal home, non-occupation of the property didn't in itself bring the tenancy to an end. As I'd said, the tenancy hadn't been terminated by the first anniversary, so a new period arose. And there had been no offer of, there'd been no, as I said, no notice to terminate by the landlord. And so the other way that the tenancy could be terminated was by way of surrender. There'd been no express surrender, and there'd been no surrender by operation of law before the tenant was evicted. So this left us with various possible dates to which we could claim that damages should run. So the first is her leaving the property or deciding the next day that she wasn't going to return and accepting temporary accommodation. That would have given her one night's damages. Was it instead that her failure to pay rent the next month? But that didn't seem to be a kind of very clear, there was no clear basis for saying that amounted to a surrender. Was it her failure on some unspecified date to actually follow through on the first letter for claim and issue a claim for reinstatement? But that didn't provide a very, it didn't provide a defined point, but also again, that in circumstances where she wasn't reliant on Section 5, that again didn't actually provide a very satisfactory point, a satisfactory mechanism for saying that the tenancy and her right to occupy had been brought to an end. Was it then the end of the next period of the tenancy on the 13th of January, which, because she'd been evicted so early in the second 12-month period, gave her almost a year, 351 nights. Again, even that didn't give a terribly clear mechanism for surrender, because effectively we would be saying, well, she's reached the end of the period of the tenancy and isn't trying to get back in. But as I said, given that occupation isn't a requirement for continuation of a periodic tenancy, it's not very clear the basis on which that would be said to bring it to an end. Was it something to do with when she was provided alternative long-term accommodation by the local authority, or when she sent a second letter before claim making clear that she wasn't seeking and making express that she wasn't seeking reinstatement? Was it the issue of a claim without seeking reinstatement, or was she in a position where in fact the tenancy had been ongoing the whole time because we hadn't found a mechanism to say it had been surrendered? That seemed to be a conclusion against which the court would strain a little bit. It didn't seem to be a kind of realistic description of what the parties considered the position to be by 2 years, 3 years down the line from when she was evicted. It also raised the question, well, if the tenancy had continued until the date of issue, she was liable for rent throughout that period. Was there going to be a counterclaim? So it was a difficult decision about how we were going to express this. In the end, the solution that we settled on, and it's not necessarily a perfect solution, was that we pleaded that she was entitled to a nightly rate for 351 nights until the end of that annual period of the tenancy, or such other period as the entitlement to occupy the property continued, and citing Smith and Khan, kind of making clear in the particulars that there was perhaps an issue about this, but picking a period that we thought was a kind of credible period, We then, because default judgment was entered, on seeking default judgment, we also proposed directions which made provision for the landlord to notify the court of any dispute as to what was pleaded about damages, and he didn't do so. So on that basis, and in any event, the district judge accepted that the tenant was entitled to damages for the remainder of that 1 year period. And in effect, the basis of the decision was that at the end of that period, the tenant not seeking reinstatement at that stage and having not sought reinstatement, it must effectively have amounted to a surrender by operation of law. It's not a conclusion which is kind of very satisfactory in its mechanism, but it was the best that we could do in those circumstances, given the problem presented by Smith and Carn. And so that, because of the length of the period, resulted in a significant award of damages, £150 a night for 350 nights, and then the other awards for harassment, aggravated and exemplary damages. Finally, then, I've a kind of roundup slide at the end. Other awards to note, there's a case of Vada and Property Arc, which was a slightly unusual case in the sense that it was long leaseholders who were denied access by the freeholder. It's useful as an indication of an award over again a fairly long period of exclusion before they were reinstated, 372 nights, and they got about £100 a night, and a reasonably high award of aggravated and exemplary damages, as you can see. The case of Anya and Anya is notable as, I think, the highest nightly award that I've been able to find. They were quite extreme facts, slightly unusual in terms of liability, in the sense that it was the licensee of the deceased owner of the property, and there was a question under the inheritance provision for the Family Independence Act, I think, from what I've been able to work out. The report's fairly short. The claimant was vulnerable, was evicted during the COVID pandemic without her medication, without her shoes, I think. So it was quite extreme facts for a very short period of 4 nights, and she was awarded £1,000 a night, which is some way above the upper limit that I'd found previously. And then the final case to mention, and I'll just touch on this very briefly because I understand that my colleague Cara Hall is going to deal with damages under Section 28 of the Housing Act 1988 later. But the case of Wilson and Wilson is a recent example of an award in a case like that. And that was, again, slightly unusual because it was somebody with a lifetime interest to occupy the property, and there was an award of 148,000 in that case. So with that, I'm going to pass over to Gus for a rather different approach to civil damages, this time focusing on the police.
Thanks very much, Dan. Hi, everyone. Great. Okay, so I'm going to start with an apology, which is that I am not a housing lawyer. So 95% of what Dan just said, I didn't understand. What I am is a lawyer who practices in the area of actions against the police. And as a lot of you may know, that work draws quite heavily upon positive duties under the European Convention on Human Rights in circumstances where the police have failed to prevent crime or failed to take appropriate steps once they receive credible allegations that certain types of crime have been committed. And that work has been primarily developed not in the unlawful eviction sphere, but in the sphere of serious sexual violence, serious physical violence, and also in cases where people have died. But I became interested in this area actually because back in the days when Twitter was still Twitter and it was good, I was scrolling through and the algorithm for some reason sent me a tweet from Ben. And Ben was complaining about the fact that yet again there had been a failure by police to protect someone from an unlawful eviction. And I think you said that you had been working with the police over a number of years to try and educate them that unlawful evictions, breach of Section 1 of the Protection from Eviction Act is a criminal offence. It's not a civil matter, as I'm sure lots of you will often be tired of hearing the police say. And I don't know if you said, Ben, I think it's time to start suing them. But if you didn't, I kind of inserted that into your text message. And then I came across an article that Dan had written on the Doughty Street website about the circumstances in which Article 8 of the European Convention might impose positive duties on the police in the field of unlawful evictions. So starting with the very basics, I've just put up the text of Article 8 there. And you can see that in Article 8.1, there's a specific reference to protecting the right to one's home. Thank you. Article 8.2 talks explicitly about public authorities and the need for public authorities not to interfere with those rights. As I'm sure a lot of you know, Article 1 requires states to secure the rights set out in the Convention within their jurisdiction. So Article 1, combined with other articles, has given rise to positive duties. And I mentioned that those are much more developed in the context of Article 2. So, for example, failures to prevent deaths by suicide when people are detained in mental health hospitals or otherwise in contact with mental health services. The DSD case in relation to Article 3 is about the Met's failures to effectively investigate allegations against John Warboys, who was the black cab rapist. And Article 4 in relation to failures to investigate and prevent forced labour and slavery. So less clearly defined in relation to Article 8, but I've set out some examples there of situations where the courts have identified positive duties on the state in relation to breaches of Article 8 by non-state actors, so by private third parties. So, for example, in the case of Waxman against the Crown Prosecution Service, the court found an unlawful failure by the CPS to prosecute in a case where there had been a harassment order that had obviously been breached in a domestic violence context. But the case that really allowed me at least a way into this area is the case of Janssens and Latvia, which a number of you may have heard of. But if not, don't worry, because we're going to go through it in some detail in this session. Just going back to the ways in which the convention duties break down. So we've talked about the negative duty. So the state can't, police can't come and kick you out of your house. Of course, there may well be situations, circumstances in which the police are effectively assisting a landlord in unlawfully evicting someone and saying, look, come on, you've got to go. You know, you're not allowed to be here. That could well be a breach of the negative duty. But there are then these positive duties as well. And they haven't been clearly spelt out in relation to Article 8, as I say. But broadly speaking, I think we can identify what's called an operational duty, sometimes referred to as a protective duty. So in circumstances where the state is aware of what we might categorize as a real and immediate risk of a breach of convention rights, an ongoing illegal eviction, for example, that there is a duty, we could argue, on the state to take steps to bring that, to avert that breach or to bring it to an end. A procedural duty, which is also sometimes referred to as an investigative duty, on the state to take steps. They don't have to carry out a perfect investigation. They don't have to carry out, they don't have to secure a prosecution in every case, let alone a conviction. But they have to take steps which are sometimes referred to as being prompt and effective in order to ensure that credible allegations of certain types of breaches are investigated. And we'll come on to whether or not that procedural or investigative duty applies in relation to unlawful evictions, and if so, to what extent. And then a systems duty, a duty to have in place a legal and procedural framework to ensure the protection of those rights. Certainly at a legislative level, the question then becomes how far down the kind of ladder does that systems duty penetrate? Does it, for example, require police to be properly trained in relation to the criminal offences associated with evictions, for them to be properly supervised, for there to be proper oversight and monitoring of the extent to which those duties are being complied with, or those crimes are being investigated? And a lot of that is up for grabs at the moment, I think. So in the case of Janssens, just very briefly, so this was a case in which it was held that the tenant didn't have, or that the applicant to the European Court didn't have a tenancy as such as defined within Latvian law. Rather, there was an agreement on the use of premises that ran until July 2011. But prior to that, whilst it was enforced, the building had been sold at auction. And in May of 2012, the new owner asked the applicant to vacate. They didn't, and then there was quite an unpleasant eviction involving the deployment of armed security guards. The applicant called the police for assistance. The police turned up, didn't do anything, and left. Subsequently, the applicant called the police again, and he was told, well, you can come to the police station and make a report. That would obviously present a real practical difficulty in that when he comes back to his property, he's going to be prevented from re-entering it. An observation that was made actually by a Latvian ombudsman, but it's quoted in the judgment, I think probably will be reminiscent of the situation here, in that the ombudsman observed that state police did not engage in disputes regarding unlawful evictions, considering them to be of a private nature. And in fact, bailiffs, as representatives of the state authority, sometimes even participated in those unlawful activities, which, as I say, there may be some similarities with the situation in this jurisdiction. So first of all, the court considered, with reference to other authorities, what constitutes a home for the purposes of Article 8. And it made clear that a home is not limited to those premises which have been lawfully occupied. And you have to look essentially at the factual circumstances, namely, is there the existence of sufficient and continuous links with a specific place? So the basis on which the criminal investigation, the domestic criminal investigation, had been discontinued in Latvia was that there hadn't been a tenancy. So the courts in Latvia said, well, on that basis, it's not unlawful to evict this individual. But the Strasbourg court, applying its jurisprudence, looked at home in terms of Article 8 in a broader sense and said, you know, look, clearly this is an interference with the right to Article 8, referred to eviction as being the most extreme form of interference with the right to respect for one's home, reflecting on other authorities. I've quoted a fair bit from the judgment here, and I'm not just going to read it all. It's there in the slides that you can see. But I think Janssens is strongest in relation to the operational duty. So it's strongest in relation to the point that in circumstances where, I'll just read this first bit, that under certain circumstances, states have positive obligations to take appropriate measures to assist an individual who has sought such assistance, so ask the police to come and prevent their eviction in the face of an attack by a private person on the right to respect for one's home. Such an obligation must be considered to be triggered in particular when an individual calls the police to defend him against persons trying to evict him by force without any legal authorization to do so. So that's pretty clear. It's a pretty clear statement that there is a positive duty on the state. And generally speaking, although the duty is owed by the state, it's going to be the police, I'm sure you all know, who are going to be the ones that tenants are calling for assistance. It's going to be the police that have the 24-hour response capability. So they are the state agency most obviously able to discharge this positive duty, this operational duty on behalf of the state. And the court was critical of the fact that the police in this case, when they turned up, didn't warn the owner's representatives, the landlord's representatives, to cease limiting the applicant's access to the apartment, and also didn't warn them of potential criminal liability, because there's a system that exists in Latvia which is very similar to the system here, which is that it's a criminal offence to evict someone in the absence of an appropriate court order. So that's a sort of a baseline that we can refer to in terms of what we might say the police in this jurisdiction should be doing. They should be warning landlords that they are committing a criminal offence, and they should be directing landlords to stop interfering with the tenant's right to access their property. And we'll come on in a bit to a policy that's in place here in London, a Met Police policy that fleshes out what that might actually look like on the ground. I know we want to leave some time for questions, so I think I will just skip over this slide, except as to say that it emphasises that it's important to have procedural safeguards in place. It's important to have a legislative and regulatory regime, but they have to be operative, they have to be effective. And the court refers to procedural safeguards in Latvia being effectively rendered inoperative as domestic authorities fail to adhere to them. The regulations created to protect the guaranteed rights serve little purpose if they are not duly enforced. And again, most often it's going to be the police that are the agents of the state most able to enforce those rights on the ground. I mentioned earlier that the existence of an investigative duty in relation to unlawful eviction is less clear. There is a reference in Janssens to the criminal proceedings being ineffective, in that they afforded no protection in a situation where tenancy rights with respect to the person's home were in dispute. But that seems to reflect the fact that in the Latvian system, and I have no idea to what extent, but I assume this is representative of the kind of European system in general, as opposed to the common law system here, that in criminal proceedings, in addition to there being a state criminal sanction, there may also be, similar to the civil system here for obtaining injunctions, a remedy that the criminal courts can apply to ensure that the victim can be returned to their property. And so in that respect, this may be the court talking more about what could be interpreted as the court talking about an operational duty, a duty to protect or to bring the breach to an end and to get the applicant back into the property, as opposed to sanctioning the landlord or the property owner with a criminal sanction. So as I'm sure you know, in claims under the Human Rights Act and for breaches of convention rights, we don't talk about damages, we talk about just satisfaction. And the Strasbourg court regularly just pulls figures out of the air with absolutely no explanation as to how it's arrived at them. So here they consulted a Ouija board and they decided that €8,000 was an appropriate award. Converted to sterling, uprated for inflation, and also you need to take into account the difference in the cost of living between the member country where the award was made and the UK. And the OECD has some statistics that are quite helpful in terms of working out that differential. But that results in an award of about 12 grand now. There's scope for increases on that because there were factors that weren't present before the court in Janssens. So, for example, there wasn't any evidence of psychiatric injury. There wasn't any claim for pecuniary losses. And the quantum judgment in DSD, the case about the victims of John Warboys, the quantum judgment there at first instance, Mr. Justice Green sets out a long list of factors to be taken into account when considering quantum for breaches of convention rights. That is, it's an Article 3 case, but you can still argue by analogy in relation to Article 8. So just a bit more on the limits of the investigative procedural duty, that there isn't a clear authority that we can look to and apply in our domestic context, where, again, our criminal system, of course, it's not focused on securing a remedy such as reinstatement. It is on expressing the state's disapproval of the conduct and applying the appropriate sanction. And there just isn't a clear authority that we can point to at the moment saying that that approach should apply in the context of unlawful eviction, such that it's not just appropriate for there to be a system of civil law and criminal law, but that individual investigations on the ground need to reach a basic standard of effectiveness. And at the moment, that's an argument that's up for grabs. And it would need to be made by analogy with other cases in which the courts have found that breaches of Article 8 in a non-eviction context, or largely in a non-eviction context, give rise to that kind of investigative duty. And of course, that's going to be relevant in circumstances not where you're bringing private law claims for damages, but where you're seeking to argue that the police or the local authority need to be taking steps and are acting unlawfully if they don't take steps in relation to carrying out an investigation, for example, if necessary, arresting the landlord, doing all the things that the police should be doing in any kind of criminal investigation, which, you know, I'm amazed learning about the way in which criminal investigations are or aren't carried out in this context. There's a whole range of tools and facilities and resources that would be deployed in lots of police investigations, but just aren't available to, for example, local authority investigators. But anyway, so there are other cases, Article 8 breaches giving rise to this investigative duty. But I think broadly speaking, what we're talking about is the worse the case. So if it's a legal eviction involving violence, if it's an illegal eviction involving racism, if it's an illegal eviction involving particularly vulnerable tenants, including children, then it is going to be easier to argue that there is an investigative duty that arises under Article 8, and the police will be acting unlawfully if they don't comply with that. Just moving on then to, I talked about this, this policy that's in place within the Met, the Landlord Tenant Guide. And although it is, it's a Met policy, it's owned by the Met, it's got their logo on it and everything. My understanding is that they may have had some significant assistance in drafting it, perhaps by safer renting. But they've stuck their logo on it, it's on their website, it's theirs now, and they've got to comply with it. And I think it's a really helpful document if you're dealing with the police in a situation where you have someone, there's an unlawful eviction ongoing and you want to refer, when I say the police, I mean the Met, and you want to refer them to one of their own internal documents, because there is absolutely no chance that any officer who's called out of a night has ever seen this document. It's just, it's squirreled away somewhere. I mean, I've included a link to it on their FOIA publications page. The version that's up at the moment is marked for a review. It was due to be reviewed in August of last year, and I've just sent in a FOIA request to ask if there's an updated version. And if there is and they disclose it, then it should go on their publication page as well. And it's very clear in terms of guidance to officers. So any attempt to evict a renter without a bailiff's warrant, which I understand is sort of colloquial reference, but without a bailiff's warrant is a criminal offence. And that those evictions must be overseen by a court bailiff or high court enforcement officer. It even provides guidance saying that county court bailiffs don't work outside of office hours or on weekends. So if you're turning up as a police officer to an unlawful eviction in hours, or to an eviction in hours where bailiffs don't work, chances are it's going to be an unlawful eviction. So the question then becomes, well, what should officers do about it? And there is guidance in this document. Once it's been identified that a bailiff isn't present, and therefore it is an illegal eviction, first of all, notify the landlord that if they carry on, they'll be committing a criminal offence, and arrest if necessary. So in terms of the criteria for making a lawful arrest, there will be some circumstances in which, even though the officer has reasonable grounds to suspect that an offence is being committed, it may not be necessary to carry out an arrest in order to investigate that offence. But if the landlord is just saying, I'm just going to do this, and they're not listening to the police saying, well, what you are proposing to do is unlawful, then that necessity criteria is met because it's necessary to prevent a crime from being committed. And then request the landlord to let the tenant back in the property. The document doesn't then specify what steps the police should take, if any, to assist a tenant in re-entering the property. But I think there is an argument that can be made that certainly pursuant to the police's broader powers and duties to ensure, to keep public order, that if they are on notice that a tenant has been unlawfully evicted, then they should be attending when the tenant or their supporter representative calls out a locksmith. They should be attending in order to keep the peace, to prevent that locksmith and the tenant from being harassed while they're gaining access to the property. And then finally, presumption in the tenant's favour. It is likely that the evictions that MPS officers attend are likely to be illegal, which is, I mean, it's a punchy line, but yeah, it's there. And therefore the presumption is in favour of the tenant to remain in their home. So again, hopefully a helpful line to refer officers to if you find yourself in that difficult situation. Even for the tenant to have a copy of that policy that they can show to officers when they turn up. And then just very briefly, just in terms of procedures, I'm sure as you all know, the primary limitation period for claims under the Human Rights Act is within 1 year, although the court can allow those claims to be brought outside of that primary limitation period where it would be equitable to do so. The Limitation Act doesn't apply directly, but some of the factors that are referenced in it can be argued by analogy. limitation amnesties can be entered into. Oh, it's lunch.
Not.
That's right. No, I just suddenly ran out of road there.
We've
But
got
we actually had questions.
we've got a little bit of time for questions. I mean, my takeaway from those 3 brilliant talks is that there's lots of scope to think creatively about types of claims you can bring, different types of remedies which arise from those claims, period, rates applicable to, quantum damages, and also what more we could do to get the police to do their job. Has anyone got any questions? We've got 10 minutes, maybe 15 at the back. Marie is roving with the mic.
It's not going.
There we go.
Hello. Hey. Yeah, thank you so much for those talks. I know that we're primarily talking about landlord-tenant relationships, and that's obviously the focus of the conference. But I've dealt briefly before with people who are occupying properties not under a tenancy agreement, either like as a political occupation thing or as a long-term sort of like squatted properties. Do you think that those rights that you brought up under the Human Rights Act, if they can make out that nexus that they would consider it a home, you can still make those sort of claims? Or is there some other bar where they haven't got any justification for being on the property in the first place that would stop that duty on the police to either assist or not assist the landlord in the eviction?
I mean, I think the relevance of somewhere being someone's home, its relevance is primarily in relation to Article 8(1). So is there an interference? And it may well be, depending on the particular circumstances, that removing someone from a property that they have occupied unlawfully is an interference with their Article 8(1) rights. That doesn't then mean that there's been a breach of Article 8, because Article 8(2) sets out the circumstances in which Article 8(1) can be infringed lawfully. And so it's going to be very fact specific, but I think that it would be, I mean, you're going to be on difficult ground in circumstances where you can't point to a specific criminal law provision that has been breached and seeking to remove the person from that property.
Yeah, just to follow on from that, I know that you kind of the hook that you were hanging things on in terms of the criminal offence that might be in play was the Protection from Eviction Act provision, and that refers to protecting a residential occupier, which is defined. And I think you're going to have difficulty potentially with that definition in those contexts. So again, it's going to be, I mean, there's a harassment offence as well, but you're going to be thinking in the context of where's the criminal offence in the mix as well, in combination with how does the justification stuff and 8(2) apply.
There might also be Article 10 and 11 considerations as well if it's a political occupation. But still, those are obviously also qualified rights. And in circumstances where private property has been occupied unlawfully, there is going to be a limit in terms of certainly getting assistance from the police, and also getting assistance from the courts more generally.
Thank you.
Any other questions? Middle front.
Hello. One thing that I've had trouble with when trying to get assistance from the police for a tenant is that if you report it to 999, officer attends, or a group of officers attend, and there's no investigation, or you bring up allegations and send it to the local neighbourhood team, and they then tell you that they don't take reports of crime to their inbox, so nothing's going to happen. In situations like that, obviously, the clear escalation would be a PAP saying, you're failing in your duties. But I wonder where that would be sent and whether there are perhaps other, although not legally binding methods, that might be more practically, quickly useful to getting the police to take action if you're following all the correct steps with officers on the ground, but nothing's actually happening.
So there is a, in terms of who's best to report to, I mean, obviously in urgent situations, you say 999. If you're not getting a response from that, there is the Met's online portal, which at least gets you a reference that you can then follow up on. But if they're not taking appropriate action, send a complaint. Submit a police complaint. I've done that before in cases where there wasn't any progress being taken at all in relation to allegations against the landlord that my client had raised. And that then resulted in the investigation being picked up. The investigation then subsequently had problems, but submit a police complaint. And you can do that probably most easily through the IOPC website. It won't be the IOPC that will be investigating, but they will then refer it through to the relevant professional standards department. In the Met, it's the Directorate of Professional Standards. And I think if you go straight to a PAP, I mean, obviously it depends on the urgency, but if you go straight to a PAP, then you could find yourself in some difficulty around alternative remedy. They could say, well, why haven't you made a police complaint?
Any other questions?
Hi, this is more of a question for Dan. In relation to damages, where the client is not seeking reinstatement, is it generally the case that we're always trying to distinguish from Smith and Khan? And practically speaking, would it just be trying to take clear instructions as to why the client is not seeking reinstatement? Often it's the case that the client just doesn't want to go back to the property because they're scared. Yeah, I just wanted your guidance on that.
So I think it's not, often, I mean, as the Venton case illustrated, often you're in a slightly different situation in relation to the underlying tenancy situation. So if you're on an express periodic tenancy, or I think if you're already under a statutory periodic tenancy, then you don't have quite the same crunch point as existed in Smith and Khan. That's another area I think where it's untested, where Smith and Khan leaves a question is, what if you were occupying at the date of the expiry of the fixed term, the statutory periodic tenancy arose, and then you were unlawfully evicted? It's not clear to me exactly how Smith and Khan plays out in those circumstances. The other point that I intended to make and completely forgot when I was doing my presentation is that where Smith and Khan leaves you in difficulty in relation to the period, one way of plugging the gap, so to speak, might be to focus on making really robust arguments on aggravated and exemplary damages, to say, well, look, this landlord was so terrible that the tenant doesn't want to move back in. But if that's going to leave the tenant short on what they would otherwise get in terms of damages, then that should be reflected, because otherwise, in effect, the landlord is profiting from being so horrible, or from reletting the property very quickly, or on aggravated damages, looking at the circumstances and what actually ended up happening in terms of how long it took the tenant to get alternative accommodation, etc. The basic damages, because of that cut-off, wouldn't adequately compensate for the injury suffered. So I think those are different ways in different cases.
I think one thing people could usefully do as well, you see in the kind of examples that Dan's given about widely different approaches to rate on period, report good results so that we can rock up to court with a list and say, this was factually similar, high rate. It's really, really useful, because if people don't report them, we don't know what the court's doing. Any other questions? We've got 5 minutes. No, early lunch? Early lunch, okay. If you could be back by 2:30, I think there's going to be...
Sorry, lunch is at room.
Lunch is in room 4. And come back here for 2:30, please. Thank you.
Stuff in terms of interactions with individuals and how they handle that. So I do a bit of restraint claims.
Right,
And I
okay.
read the V&H case, right?
Yeah. I was a paralegal.
Where you?
Yeah.
So I'm really, because I do a lot of disability related work. I've got some social care. I've got a social care client at the moment who is being prosecuted for property damage in her own home in relation to amount.
Right.
And I know from a couple of criminal colleagues and sorry, and this is not seeing more claims being prosecutions, dissemination, terrorists.
Right,
And
okay.
it's like, it's an area that I'm not a criminal practitioner, I don't really do actually.
Sure, sure. Yeah, yeah. To be honest, it was something that used to crop up quite a lot.
Yeah.
We used to get quite a few cases in where people had been, for example, stop and searches had gone wrong. Because of concerns of being touched and yeah, exactly. Yeah, no, it was right.
I'm just like.
Yeah. No, it was pretty grim. And it was weird that it was one that they decided to find. And there was a mediation here. And they were, yeah, it was Anna Stone. Hello. Oh, okay, perfect. I might be able to answer it. Okay.
She's being evicted for rent arrears. So that's what she checked with me.
Okay.
Alongside that is.
Great. Thank you, everyone. So this afternoon we have two parts of a session on skills and practice with another coffee break in the middle. You'll be pleased to hear. And the first session, we have a series of talks from the lovely people around me, who I'll introduce shortly. And then we've got a whole slot for questions after the coffee break, so you can think of some really clever things to ask during that time. It'd be great. So I've got to my far right, Marie Paris, who many of you will know, who has also played a key role in organising today's fantastic conference. And she is going to be speaking about obtaining interim injunctions, first of all. And then actually everybody's seated in order, which is quite nice. We have Will Ford from Osborne's, who again, I'm sure many of you are familiar with, and who we are grateful for all his work on some excellent High Court judgments in relation to housing needs assessments in the homelessness context, which we use day in, day out. Thanks, Will. And he's going to be talking about obtaining information and using investigators. To my left, we have Cara, who is one of our more recent recruits and is outshining some of our more senior colleagues already. She's going to be speaking about obtaining and working with valuation evidence. So when I spoke earlier about section 27, claims in the context of unlawful eviction, and I said section 28 will tell you how to quantify that, Cara is going to be speaking to that. And then last but not least, we have John Hobson, who'll be talking about enforcing money judgments and injunctions. And I don't think John needs introduction either. I'm sure he'll be very familiar to all of you. So without further ado, take it away, Marie.
Hi everyone, can you hear me? Firstly, cool, awesome. So injunctions and unlawful eviction. My focus today is going to be on interim injunctions because I think that's where the most commonly used injunction in unlawful evictions. There's probably a variety of experience in the room, probably a lot more experience than I have personally in actually getting interim injunctions. But these are just sort of the basics, but also practical tips on how you get them, how you manage them, and more importantly, what you do after you get them. So some of it's a bit scary, but it's okay. It's better that you know. So when might you need one? This is, I think most of you know, but you might need to be looking to issue an urgent injunction when you've got a client that's already been evicted. So they show up at your firm with their stuff in their hands. You might want to get a prohibitory injunction where they have been told that they're about to be evicted and you know full well that that's going to be an unlawful eviction. That happens all the time. You can get one if your client's just being harassed. So a bit more on that later. It's much easier when it's in the context of the other stuff. And also, again, this is a one that's good to pop on when you're in the context of other stuff. But if you've got a landlord that's doing a sort of constructive unlawful eviction, turning off the supplies. I've got one at the minute where they turned off the Wi-Fi, which is very cruel. That sort of thing on its own, a little tricky. So, but in the context of other stuff, quite compelling, I think. Hopefully the court agrees. So very boring basics, but what's the law? What are you actually trying to persuade the court? I think I include American cyanamide, which is the classic, just to remind everybody that it is, a little bit more generous, especially in the context of unlawful eviction where the judge is on side anyway. It's a little bit more generous than some judges sometimes think it is. So some judges just immediately think that you've got to have 100% chances of success. They have to be completely convinced on your case before they can make an injunction. I think probably because they're thinking a bit about disrepair, but it's useful to remember that actually that's not the test. So what you're first looking at is whether there's a serious issue to be tried. In these sorts of cases, there's almost always going to be. I mean, you're asserting a right of possession. You know, whether your landlord agrees with you or not, or if your landlord says, oh, they surrendered, or they actually just moved into my house against my will, or whatever, these are obviously serious issues to be tried. They're not frivolous. The second part, again, should be an easy hurdle to clear, whether damages alone are going to be adequate compensation. So if you've got a circumstance where somebody's been evicted and they're on the street, obviously damages on their own are not going to be adequate compensation. And, you know, equally, if they're about to be evicted, it's very unjust to just allow them to be evicted on the basis that they might get damages in a year's time. So yes, and also courts should be, I think, aware, whether you want to make a submission on it or not, but aware that it takes absolutely ages to get damages at the minute. Courts are really, really busy. So, you know, are damages alone going to be an adequate compensation in circumstances where they're going to be in about 2 years' time? Maybe not. And the last one is the one that can be a bit tricky, which is whether the person applying for injunctive relief would be able to meet the costs incurred by the person against whom the injunction is made, if later on it means that they shouldn't have had it. So basically that just means, can you insure the landlord in this case against, you know, the risk that this is all very frivolously bought? Are you going to be able to pay them back at the end? I think that it should be, oh, thank you, Clem. I think that in most of our cases, particularly where they're publicly funded, it should be very much stressed that that should not be a basis for not making an injunction. There's a case called Allen and Jambo Holdings from 1980, which is quite helpful, which is just an example really, but it's an example where the court said, look, I'm not going to not make an injunction just on the basis that this person is impecunious, so not minted. Particularly in circumstances where they're legally aided, so that's helpful, because otherwise we're never going to be making injunctions for people that are of lower means, and that's just a really unfair hurdle, and that's not how the justice system should work. But also to make that a bit easier to swallow, because sometimes judges are still a bit anxious about it, think about offering to undertake to keep paying the rent. That should be really, I mean, it's not quite a cost undertaking, it's not as dangerous, but in those, you know, it's a way to sort of fix the balance and make the court think they're not doing anything too drastic because this person's going to carry on paying the rent. Here are some other principles that you might want to think about. So one is that the court must be satisfied that the interference with the claimant's rights is continuing. And in our cases, that's almost always going to be the case if they're on the street. Where there's a substantial interference with the claimant's rights, there should be a presumption in favour of injunctive relief. So that's another good one to chuck into your submissions. And I'm saying all of this because I think we'll go into it later, but oftentimes it's going to be you guys doing it, not us at the first instance. And then there's a question, I think, of where you're trying to get an interim injunction where services are cut off, it actually sort of crosses into disrepair territory oftentimes. So you have to think about Parker and Camden, which is a slightly higher, not slightly higher, quite a bit higher hurdle to clear in getting interim injunctions in disrepair. But what I'd say is that case was in 1985. We've had a bit of success lately of saying, look, especially when there's you know, services are cut off, what you're actually doing is making the property uninhabitable. Section 9A wasn't around in 1985, so let's distinguish on that basis and say it's a bit easier. They're eventually going to disagree with me, but they haven't yet, so might as well keep going. And the other thing to bear in mind is that you want to, I think it's quite, I'll go into a bit later, it's quite often that judges, probably because they're really harassed and wrong choice of words, but they're very busy. They kind of make, and they just want to make sure that it covers everything. They'll make an injunction like, don't breach quiet enjoyment. Sometimes it's helpful to have to be a bit more specific, and particularly to be specific that what they're trying to prevent is harassment, because you can get injunctions for harassment under the PHA 1977, under Section 3 and Section 3A, when there's more than one person that is a victim of the harassment. I've given the law for harassment there, but Alice very helpfully went through that earlier on. And the benefit here is that if they breach that injunction and an injunction is made under the Act, it's a criminal offence, which is very nice. And you can apply for a warrant of arrest from the county court. So it's a little bit like an ASB in that sense. You have to do it under affidavit. There are certain rules about it. You have to be pretty sure, but it is helpful that it's something that carries powers of arrest, because you guys know what landlords are like. Sometimes they're not really into respecting court orders, so they kind of have to be made to. Another thing I've put here, which is about injunctions for apprehended breach of the Equality Act. Now, my colleagues might disagree with me. I haven't been able to find a very clear example of this actually happening, but Section 119 of the Equality Act makes it very clear that you have the county court has the same powers as they would in a case of tort, in a claim for tort, which normally means, that's why we say we should get damages, but it also means that they can make injunctions. The county court can make injunctions, and that is sort of supported by Malcolm and Lewisham, which is a case before the Equality Act, but about the DDA. At paragraph 101, they talk about the fact that there's no real reason why you wouldn't be able to apply for an injunction to stop an apprehended breach of the Equality Act. So that, in that context, it was about race harassment and racial discrimination. I don't think there's any reason why you shouldn't be able to do it in the context of the Equality Act, which is even stronger than the DDA. Something to think about.
Don't read any rest of Malcolm.
Yeah, don't read the rest of it, it's horrible, but that bit's good. Right, so into more practical stuff. The key thing is you don't have to have already issued your claim in order to get an interim remedy, so they can be granted at any time. What you might want to do in certain circumstances, and obviously not if it's going to put your client in danger, but you might want to send a letter before action if possible. Every time I've seen it, it's been very helpful, because what you're doing there is you're setting out the law and you're saying, look, if you do what you're saying you're going to do, it's illegal. And it makes it very easy for, it makes it very difficult for a landlord to show up in court and be like, oh, I'm so sorry, I didn't know. Housing was so confusing. When you've got like a lawyer saying what you're about to do, exactly the thing that you're about to do that you've said you're going to do 8 times is illegal. There's no suggestion that they're acting in ignorance, which is quite helpful. The ordinary rule is that an application should be made on notice, the usual rules under the CPR, 3 days notice. But, very often the case, that's not going to be appropriate here. So you've got a client that's on the streets, they're about to be on the streets, they're subject to serious harassment, they're in fear of violence. Letting the landlord know that you're about to get an injunction is sometimes quite a dangerous thing to do, because they're just going to move super quick. So that's the sort of circumstance where you can take the extraordinary measure of going without notice or on short notice. But if you're going to do that, I'm going to have 3 slides of very scary slides in a minute. You have to be very careful, and you have to at least try to put them on informal notice. So there's lots of stuff in the white book about how easy it is nowadays in this day of mobile phones to put people in informal notice. Sometimes landlords are really, really slippery. Part of the reason why they're rogue or criminal is because they refuse to tell you who they are. I've had a couple of those lately. So sometimes it's genuinely going to be impossible. But what I'm talking about is a WhatsApp message, a text message, try and get them on the phone. And the best thing about that is if you call them, especially before they've got a lawyer, they tend to say all sorts of really fun stuff, including, it's horrible for the tenant, but including sort of, I've had a lot of racial discrimination over the phone. I've had, just straight up admittal that they're going to do it and they know it's illegal and they don't care. This person's annoying. I've looked at the court, it looks really expensive. I'm just gonna have to do it this way. See you in court. So, that stuff is really helpful. And also, you've complied with your ethical obligations and you've put them on informal notice. That's just a case there to say you really should be putting them on at least informal notice, unless it would defeat the purpose of the application, which is, like I said before, if it's dangerous or there's literally no time. That's almost never. Okay, practical stuff. Again, this is stuff that you guys probably know better than me, but if possible, try to get counsel on standby. Getting urgent counsel, I know it's tough, but just call around chambers, see if somebody will be around on the day. They don't really need to do much except come down to a hearing, and if they have a really brief skeleton argument, great. You need to do your form, you need to do your injunction form, but you'll preferably also have particulars ready to go. Obviously, sometimes that's impossible. So you should at least have, what the CPR says is you should have at least a witness statement addressing the key allegations. And then the rest of it is what I say should go in there. The impact on the claimant, any discussion you've had with the landlord, particularly if they've said anything naughty, like I said earlier, The claimant's financial situation, so that's to deal with this idea that they can make a cross undertaking in damages, and any of their other personal circumstances. That means, you know, the balance of convenience is going to lay in favor of them getting an injunction. This, I know, is a big ask. It depends on the court, but get a counter appointment. Do not leave until you get a counter appointment. Resist being sent to the drop box. I'm looking at my solicitor here who was almost sent to the drop box in Willesden Green. That's going to make, you know, you'll get a hearing in about 2 years, which would be nice. But it's just pure persistence. Be ready, be in person. If you're not able to do particulars of claim, you can either issue the claim and then serve particulars 14 days later, or give an undertaking to issue the claim in a reasonable, well, it's in a certain amount of time. It's normally pretty much immediately. But yeah, you don't have to have your particulars in order or anything like that. If circumstances require, just get yourself down to the court. Now for the scary slides. Be wary of your ethical obligations. And I'll preface this to say, when a landlord is trying to get an ASB, they are rarely thinking about any of this, as Alice has done a hilarious case on this. But, you know, as always, we're often held to a higher standard. So be careful. You've got a duty of full and frank disclosure that falls on your client, which is important, and also on you. And that duty is owed to the court itself, which means it's scary. The golden rule is that you must identify any material facts and law, and in particular, any which may constitute a defense or some ground for not granting the order sought. It is not the same as just normal disclosure. What you have to do, I mean, disclosure is kind of a wrong way of putting it. You're basically the landlord for the, you're landlord for the claim, you're a lawyer for the claimant, and you're also the lawyer for the landlord. So you need to, you know, put as fairly as possible what their case would be. So,
which is based on your phone call to them.
yeah, exactly. Which is exactly, that's another reason why it's a really good idea to have a phone call with them. Because you have to put that in as neutral a way as possible. But if they've said something crazy and you put it in a really nice, neutral way, you suddenly look very reasonable and they look like they look. So here are the rules. I won't go through them in too much detail, but you must basically show utmost good faith and disclose the case fully and fairly. Yeah, if there's any evidence that they've given you, you need to hand that over to the court, even if you think it's nonsense. It's always best to just get that over there. I'm thinking photos, you know, complaints that they have about the tenant. Obviously, you often know that that's not really relevant. It's not going to be a clear defense, but it's just safer to put that in front of the court so you can avoid any sort of dangers later on. You have to identify the crucial points for and against the application. Don't rely on sort of general statements. This is the important one, I think. You have to investigate the nature of the claim. So, and it's difficult, I think, when you've got a person that's just come into the law centre or, you know, your solicitor's office with all their stuff in plastic bags, desperate to get to the court. You do have a duty to investigate the claim fully before you issue an application without notice. Yeah, disclosing all the facts. Help the judge, basically. Don't mislead the judge. What does that mean, really? So as I say, I think the most important thing is that you need to sit your client down and say, we're about to do something that the court considers to be extraordinary. I know for you and I, it probably seems a bit routine because unfortunately unlawful evictions happen all the time, but it should be stressed to them that it's an extraordinary measure. And they need to tell you everything. And I know that's difficult because they're going to tell you stuff that happened in the, you know, the 20th century, including stuff with other landlords. Try and limit them, but they need to tell you, you know, have they spoken to their landlord about moving out? Have they gotten into a fight with the landlord? I've had, you know, do they know the landlord? Is the landlord their dad? You know, this is stuff that sometimes only comes out after the flurry of trying to get your case to the court. You need to try and iron that out early doors. And that's a duty that falls on you. If you did manage to speak to the landlord, as Will anticipated, put forward their case, including any evidence that they sent to you. And as Will said, sometimes they're saying stuff that, you know, as Will suggested, sometimes they're saying stuff that is particularly unhelpful. Don't wink and nudge at the judge. Try and put, your duty is to put it as neutral a manner as possible. I don't think I need to tell you this, but you wouldn't be complying with your duty of full and frank disclosure if you put your case beautifully and then you were like, and the landlord might say this, but it's a bit weak. You're going to get yourself in trouble. Judges know. there's this, I'm cautious about it. You might have to tell the court about the existence of without prejudice talk. So that doesn't mean that you need to tell them what you actually spoke about, but you might need to tell them that it exists, and it's only if it's relevant. The guidance in the white book is very optimistic about what you can do on short notice. I think it's because it's thinking about freezing injunctions and oligarchs and stuff. They say that you should put in a skeleton. It's really good, especially if you get counsel, to put in a skeleton. Even just have it to hand maybe in your office of just like what American cyanamide is, the real basics of unlawful eviction. Just so you can like print it out and hand it up to the judge. But they say put in a skeleton, good luck, but it'll be nice. And a draft order, that is very impressive. And if you can't, be sure to be prepared to put the full factual and legal framework across fully and clearly to the court and orally, and keep a note. So the note is very important. So oftentimes you're going to go in, the judge has already read the papers, they're obviously satisfied that something very bad has happened. They want to see you for the least amount of time as possible. They barely say anything. It's helpful and it's important, I think, that you try and occupy them for a bit of time so you can say the basics of your arguments, the basic of the landlord's arguments, so that you've complied with your duty of full and frank. Keep a note. The note needs to cover what you've put forward on your case, on your case, what you said about the landlord's case, what the judges had to say, so not just what their order is or what their judgment is, but if they had any questions or queries. And that needs to be served on any party affected, but particularly the respondent, with all expedition, so ASAP. Even if you do it by WhatsApp. Preferably don't do it by WhatsApp, but if you have to. You cannot rely on there being a transcript, so there's amazingly went to the highest court, I think, at this point, and maybe it's the Court of Appeal. You can't just rely on a transcript. You should also serve a list of the allegations that you've put about the landlord in a formal witness statement as soon as you can. If an order is made, obviously that needs to be served on the respondent with all expedition. And the trouble is, if you mess up on the above, the injunction can be discharged, that's really clear. They might get indemnity costs, and they might even get wasted costs. So you have to be very careful. And oftentimes the landlord's case is terrible anyway. So, it's just cover your backs, get it across. The risk of you damaging your own case is very low compared to the risk of damaging your case if you don't comply. Even if you go on short notice rather than without notice, the duty still applies to you. It's applied in a slightly modified way, which is just common sense. It's modified in the sense that if somebody shows up and puts their case forward, you don't need to repeat what they've said to the judge. If they show up, you're okay. But you just have to still be mindful. The duty still applies to you, even if you gave them 2 days, 1 day, and they show up. The idea is they might not be fully prepared because you've not given them enough time. What are you after? Sorry, getting ill. So it helps to be specific in your injunctions, as I said, rather than really general. I think there's a temptation to be really general because you want to have like a catch-all that gets all the different nasty things that a landlord can do. It's good if you can get that in as one of the terms, but I'd always advise also being quite specific, because just on a practical level, a lot of the people that you're getting these against are litigants in person. They don't know what breach in quiet enjoyment is. And there also might be sort of unique circumstances in your case, which means that it helps to be specific. I've got a case at the minute with somebody here, hello, where previous counsel had gotten a good interim order, very broad, very nice, but obviously the landlord owns the house. The client's room is one room within the house. So obviously what the landlord's done is gone back and knocked on all the doors and sat in the kitchen and done all sorts of stuff. It is a breach of quiet enjoyment. Are you going to prove it to a criminal level? Is it an enforceable injunction? You're much better off spelling out what that is. So think about it. Do you want the landlord to change the locks? Would you rather they just give you the keys? What's going to happen more quickly? You want to say that the landlord can't attend without 24 hours notice. You might want to say that the landlord can't swear and shout at you if it's, abusive. You need to put that in. I've put here that you can't serve frivolous notices. There's another person here who I think is a similar case. It can be harassment if you serve about 200 completely invalid Section 21s every day until they get out. So that can be very upsetting. So, if you can include that in your injunction, why not? Ask for it, see what the court's happy to make. I've put one here because I've seen it recently. Landlords sometimes actually had this a few times. They go on Facebook, and especially if it's out of London or there's like a local community, I mean, even in London, you know, the like myneighbor.com things, they'll post like, oh, I've got this horrible tenant that's taken me to, well, they won't mention that they're being taken to court, but they'll say this horrible nightmare tenant, blah, blah, blah. So you might want to put something in about them not posting on social media about the claimant, but you've got to be a bit careful because it's technically infringing on their right to free expression. So you have to be a bit more careful, but you might as well try. What happens after the hearing can be just as important. So I would always suggest using a process server to serve your injunction and have that signed off with affidavit evidence. And the reason you need that is because you might need to commit this person if they carry on doing what they say they're doing. If the landlord says the property has been relet, well, that would be a problem, but you need to, this is just on a practical level, if you can get down there and have a look, because oftentimes it has not been relet. And try and take photos, get evidence of it. If it's genuinely relet, you're in trouble. Not you're in trouble. If you've done proper investigations and you didn't think it'd been relet, you make an application, you're in trouble in the sense that the injunction is probably going to be discharged. But think about what you can ask instead. So should they be paying for you to stay in a hotel for a couple of nights? And what I'd always say, so what happens is you get your interim order, the court says, this is without notice, I'll see you back here in 5 days. The landlord will show up. I think it's always a very good idea to make an open offer that they, that you won't ask for an injunction if they give an undertaking to the court on very similar terms to the injunction. And then it kind of just puts the burden on them, because if they refuse, you're like, why? What are you planning on doing? Why are you so nervous? And then it makes the court very anxious that this person is just going to unlawfully evict them again, and if they refuse to make to give an undertaking, the court's hopefully going to make an injunction. And that's me. Is that me? Oh, thanks. Oh, sorry. And now Will Ford.
Thank you. Yeah.
Got surround sound there.
Yeah. Apologies if all of my stuff is stuff you know, but I just try to have a think about rogue landlords I've encountered and stuff that's come up. So first thing, who's the landlord? It might seem like a fairly obvious question, but in the more dubious end of the private renting sector market, it's not always that clear. Is it an individual, a partnership, company, some other bizarre entity that doesn't have any real legal entity at all? So just it's something to bear in mind when you're pleading your case, because the Practice Direction 16 does require you to specify exactly who it is, and it sets out the details of what types of people you can litigate against. So that often might require some investigation into the identity of the landlord at an early stage. So to give an example, I had a client who found a room to let through Facebook, never actually met the landlord. It was just the name of something which sounded a bit like it might be a company. People would come to collect rent in person. They were always different. He had text messages with people whose phone numbers conveniently were not operational by the time that they'd been unlawfully evicted and I was phoning them. And there was like a website, and that was it. Often it's just to do with a website and a dream. And the dream is to treat your tenants like shit. But anyway, so in that case, so we found the website. There was an email on that. We emailed them a bunch of times, no response. So I just instructed inquiry agents who were able to do lots of clever computer stuff from the IP address of the website, and they found out lots of other stuff about them. And we were able to identify 2 people that were almost certainly the people behind it, and they had properties, and they were not very happy about this. But anyway, so it's worth doing a bit of digging. Yeah, so thanks. Yeah. Astonishingly, some of these rogue landlords don't actually comply with Section 48 of the Landlord and Tenant Act 1987 and have not provided an address. It's amazing. But nonetheless, you're going to need to serve on them. So consider an application for service by alternative means. Same case where I just talked about, had a website and an email address. We made an application to service by alternative means, and you just got to demonstrate that you tried to do everything you can to get an address. And I'd phone them and they wouldn't give me their address. So it was fairly easy to get that through in the end. Extreme cases, you can consider applications to dispense with service. I've never had to do that, but it exists as an option. Then getting information. So you probably all know this, but like all the types of cases you might be bringing against rogue landlords: not protected the tenancy deposit, not complied with the prescribed information, that sort of thing. There's obviously 3 registered providers for that. You can check if you've got basic details. You better check if they have protected the deposit. Often they have not. Then another thing that might not seem that obvious, but it might seem obvious, but like just general information your client might have, social media information, other stuff they've got about them. So I had another case where it was quite extreme. So before my client was unlawfully evicted by the landlady, her son or nephew shot the window of his house to intimidate him. And now I can't prove that she instructed the nephew to do that, but for the purposes of this conference, she definitely did. But anyway, so not the nicest circumstances, and like the same evening that same gun was used in a murder. So dramatic. And her son and the nephew were all like in this criminal case. Anyway, that was ongoing at the same time. Then she just chucked all my client's stuff out on the street. But before this had all happened, they'd got on all right years before, and they'd been Facebook friends. And so she didn't file a defense. Well, she filed something. It wasn't really a defense. It basically admitted most of the things that we said that she'd done. And anyway, so we'd made an application to strike out for default judgment in the absence of a defense. And she suddenly was, oh, I can't possibly go to the hearings. I'm so stressed with my son's criminal case, and my doctor says I can't go. And then the next, literally 2 days before the hearing, my client managed to find on Facebook that she was in Barbados. It was fine. So you would have thought we would have got our default judgment. No, the judge was like, oh, we're going to make an unless order. Really? Come on. Come on. What more do you need? She's in Barbados. Anyway, so we had photos of her checking in with her champagne and stuff. It's nice. Anyway, fun times. We did win that case eventually, obviously. I'd be upset if I hadn't won that case. Yeah, so, and then the identity of a landlord might be an ongoing process. I've had this as well. You start off, you think, this is obviously this person. And I've got to a point, I've got judgment. Then some other people, they come out of the woodwork and they're like, oh, no, it's not me. It's someone else, some other person. And then you end up having ongoing disputes about that. Then, yeah, so HMO licensing, as you probably know, there's 3 types of licensing. So there's the one that applies to everybody, so mandatory licensing. Other local authorities will have additional HMO licensing, which will normally be a slightly more robust definition of what an HMO is. Or you'll get selective licensing in some boroughs where everybody who's a private landlord has to have a license. Each local authority has to have a public register, so you can search that. And then often you can search against the landlord and you'll find out other properties that they've got. In preparing for this, I've discovered the Mayor of London's got a really useful website. They've got a map. I've put a link in it in the notes, which will show each local authority and what their requirements are. And then same website, they've got a rogue landlord checker where you can see if your landlord has been fined or prosecuted for dubious behaviour. So that's also potentially quite useful. Then, yeah, you get your judgment. Brilliant. Is it worth it? Sometimes. Rogue landlord. So if it's a company, I've had this before. So they often just disappear. You get your judgment against them, you've got your cost order, and then suddenly that company doesn't exist anymore. I don't think there's much you can do about it in that scenario. So I had a ground 8 case like that where we defended a ground 8 claim, got costs against them, and then we never got those costs. Bad. But other situations, so my colleague's got a case where this is the scenario. So you've post-judgment, they'll try and transfer the name of the property into someone else. So in the case that my colleague's acting in, they got judgment. So then they issued against this company, which is now dissolved, and an individual. And then they got a charging order against that person's property, but then that person I think at some point when they came to register the charging order, it turned out that they'd transferred the property into the name of a company of which they were the sole director, shockingly. And then what's how you enforce against that? So in that case, what they're currently doing is pursuing bankruptcy proceedings against the person, and then as part of that process, seeking to set aside the transfer, because it's obviously been made in the knowledge that they've got a judgment debt, and it's hard to escape the conclusion that the only reason they've done that is to put it out of the reach of creditors. So in those sorts of situations, you might have a case to go after that property. And then I think John's doing stuff on charging orders. I got like a tiny bit on that. So the charging order itself, it isn't enough to like satisfy the judgment debt. You'd have to then push for an order for sale. I've had to do that in a few cases. Generally speaking, miraculously, just before the house is going to be sold, the landlord tends to pay up. I've never actually sold a house. I quite wanted to have charge of sale of somebody else's house, but I guess I could just do conveyancing, which I don't want to do. So maybe I don't want to do that. Anyway, but yeah, it's often going to be like an investment property. It's going to be pretty hard for them to say that property can't be sold to pay off their debts, unless they've suddenly moved into it or whatever. But yeah, the other thing with charging orders is it doesn't necessarily prevent the owner disposing of the property. So what you obviously get charging order, you protect it via a notice or restriction at the land registry, but that doesn't sort of prevent the proprietor transferring it if the person they're selling it to doesn't insist on removal of the charge. So they might transfer it to their wife or something like that. But you can apply for non-standard restrictions. There's a good bit on the land registry about this with guidance notes. I think there's some good stuff on practical law about it, and some judges don't like it and some do. But anyway, not judges, people at the land registry. Anyway, so you can apply for a non-standard restriction that would require the judgment creditor to be given notice before there's any dealings with the property. So then you get a notice saying, oh, he's going to sell the house, at which point you can make an application to try to prevent that happening, or yeah, get something before it happens. So that gives you some time. And I think that is me done.
Okay, so I think it's my turn, and hopefully you're not all sick to death of unlawful eviction, because there is more to come. So I'm going to be talking about damages under Section 27 of the Housing Act 1985, that should say, that's a typo, and how to get them in, basically. So Section 27, what is it? It basically provides a route to claim statutory damages for unlawful eviction. And you can effectively get those where your client's been unlawfully evicted, or the landlord's attempted to unlawfully evict your client and they've actually given up possession, or where the landlord does acts likely to interfere with the peace or comfort of the occupier and withdraws services and things like that, and your tenant gives up occupation. So it's really important that your client has left the property or been evicted from the property to claim damages under Section 27. In circumstances where this has happened, then has that moved on? Yes, then the landlord is liable to pay damages in accordance with Section 28, which we'll turn to in a minute. No, we'll turn to it now. Let's crack on. So Section 28 provides the basis for calculating those damages, and it's effectively the difference in the value of the landlord's interest in the property of when the tenant had their right to occupy and when the tenant didn't. So it's a difference in value between that. And sometimes there's a big difference and sometimes there isn't. And we'll turn to that in a minute. But what Section 28 is clear about is that the landlord's interest that needs to be valued is the interest in the building in which the premises in question are comprised, if they own the whole building. So that's really important to know when you're trying to determine what your damages are likely to be under Section 28. So what does this all mean in real life? So firstly, it means that damages under Section 27 can only be claimed if the tenant is not reinstated to the property. If you're not sure whether your tenant can be reinstated, so they might be, but you don't know if it's going to be relet or something like that, you can plead it and seek Section 27 damages and also seek an interim injunction or something like that. If the interim injunction is granted or the landlord lets your tenant back in, then you can no longer claim the Section 27 damages, so that will fall away. But it's worth pleading if you're not sure if you're going to be able to obtain reinstatement or not, because you can plead that alongside general damages for tort, breach of contract, which I think you heard about this morning. So you can plead both, but you can't obtain both. So if your client cannot be reinstated, you can proceed with the claim for both Section 27 damages and general damages for breach of contract, tort, or whatever. But at the hearing, you can't recover damages for the same loss twice. So effectively, you can ask the court to order whatever is highest. And that will depend primarily on the nature of your tenant or occupier's security of tenure. So security of tenure, if the tenant has good security, so we're thinking secure tenants, assured tenants, or rent act tenants, then there's a potential for a very high level of damages because the damages are based on the difference in the value of the property when they had their tenancy and when they did not. But by contrast, this also means that if you've got a client with a very weak tenure, for example, an assured short hold tenant, then the damages are likely to be much lower. And I've cited a case there, Melville and Bratton, where the Court of Appeal actually found that it was difficult to find that there would be any difference in value of the property having the assured short hold tenant and the property not, in circumstances where there were other occupiers within building. So it's just to be mindful that if your client has a weak security of tenure, damages under Section 27 might not be particularly significant. This does mean that it's quite important that you have a good understanding of the nature of your client's security of tenure, because while some of them are obviously strong, we're thinking secure tenants, a weak tenancy might not be as weak as it first appears. So for example, you might have an assured short hold tenant, but they're still in the fixed term of their tenancy and there's no break clause. So it's going to take the landlord a long time it would have taken them a long time to be able to lawfully evict them, and they wouldn't be able to do it during the fixed term, other than under Section 21. And if there's defences to that, for example, you know they've not had a gas safety deposit and things like that, their tenancy is actually stronger than it first appears, because the landlord wouldn't have been able to evict them as easily as you might think. The other point to note is that there's particular potential for high damages in cases where the property that your client has been evicted from is a flat in a building, if the landlord owns the whole building, because Section 28 is clear that the interest to be valued for the purposes of calculating the damages under Section 28 is the value of the whole building, if that's what the landlord owns. And this has potential to obtain massive damages, way in excess of loss. For example, the Supreme Court case that I've cited there, Loveridge and Lambeth, the tenant obtained damages of £90,500 for his unlawful eviction. So it's definitely worth doing, especially if you've got, it's often social landlords that own the whole building, and there's massive potential to get really significant damages for your client under Section 28. So what do you need then to get damages under Section 28? And because damages are based on the difference in value of when your tenant had their right to occupy and when they don't, you need expert valuation evidence. And so this is some practical guidance about how to get that. So the first thing that you'll need to do if you've got a case where you're wanting to claim Section 27 damages is that you'll need to apply for prior authority from the legal aid agency, because the rates for valuers are unrealistically low. It's just £40 an hour. You will not find a surveyor who will value the property for that amount. You just won't. So it's almost certain that you'll need to get prior authority in these cases. And to do that, you'll want to get advice from counsel advising that valuation evidence is necessary. And you'll also want some quotes from some valuers as well, to demonstrate to the legal agency that no one will do it at £40 an hour. After that, once you've got your prior authority and you're ready to instruct your valuer, it's really important that you are very clear in your instructions to that expert, because you want to make sure you've got the evidence that you need to actually get your damages, but also because a lot of them won't have done this sort of thing before. So you want to make sure that you tell them absolutely everything that they need to know to give you the evidence that you need. Now, this slide is a bit text heavy, sorry about that. I just wanted to make sure that when you have the, I think you all got sort of virtual handout, you've got these notes. So the first thing you want to include when you're instructing the valuer is that you want to explain your client's tenancy type and how they could have been evicted by the landlord lawfully, because they won't know how they work and what the differences are, particularly, you know, if you say they've got an assured tenancy, that they won't necessarily know the difference between a fully assured tenancy and assured short hold tenancy. So you might want to flag that no fault eviction is not available. Secondly, you'll want to set out in full section 27 and section 28 so that the expert understands the basis of the valuation. And then you want to expand on it a little bit just to make sure that it's crystal clear what it is that you need from this expert. So you'll want to explain that if the landlord owns the whole building, and you want to provide evidence that they own the whole building, so you can get the title from the land registry and send that to the valuer. You want to explain that the interest to be valued in those circumstances is that in the whole building, even if this means that the difference that they're going to calculate and the damages to be awarded are substantial. That's just the way the law works, and it's important that the valuer understands that. I think it's also important that you're very clear about what the valuer needs to determine, and you effectively need 3 figures. Firstly, what the value of the building as a whole, or the property if they don't own the whole building, was when the tenant had their tenancy. Secondly, the value of the building when they don't have their tenancy, and the difference between those 2 figures. The next things is that you need to explain the basis on which the valuation needs to be calculated. So section 28 is clear that it's as if the landlord is selling the property on the open market to an ordinary private landlord, not a housing association or the local authority, and that they need to assume that neither the occupier or a member of his family wish to buy the property when calculating this amount. You should also make sure that you've asked the expert to explain his reasoning for his valuations. So it might be, and you will have helped him along the way in your instructions by saying, you know, he might be able to say, oh, it would have been really difficult and no one would have wanted to buy it with a fully assured tenant in there, or things like that. The other thing that you'll want to address in your instructions is that if there's a dispute of fact between you and the landlord about the nature of your client's occupation, you may want to have the valuer address to provide values on an alternative basis. So a lot of the time what will happen is you'll have a landlord saying that your client had lost their security of tenure by not occupying the property as their only or principal home or something like that. They still need a court order, so it's still unlawful if they've evicted them, if they are in the property without a court order, but it's obviously relevant to the value of the property, so you might want to obtain figures on both, just so that you're prepared for future court findings. And then finally, you should remind the expert that his report needs to comply with Part 35. As I say, I think a lot of them won't have given evidence of court proceedings before, certainly not this type of proceedings. So I think it will be, you just don't want to get their report and then it doesn't comply with Part 35. I think that's it from me, actually. I'm just going to check if I have anything else to say. No, thank you, everyone.
Thanks very much, Karen. One of the things actually we were just talking in the break, the safe renting, gentleman who was here was saying that with the changes coming through to assured tenancies, this may end up being an area where there's going to be stuff that's worth a lot more money because of Section 21 goes. Then, yeah, so watch this space, think about it. John, sorry.
Thank you. Thank you, everybody, and to everybody else on the panel. It's great to see a full room of people on such a an interesting topic. And I'm always reminded on this topic in particular of cases, and we've all got them, and the anecdotes are important to share. I think it's about 15 years ago, there was a case in Manchester, which is where I'm based, and the police turned up and joined in, bouncing the client out with the landlady. And we just went for it and said, well, let's sue Greater Manchester Police as well as the landlady, which is what we did. And I always remember the case because it's interesting, it's that interface. You know, don't be shy of doing that if you've got factual nexus, which includes the police. We did that on the CFA and we had the rest of it on legal aid. But we also got our costs. And I also remember the case all these years later, because once a year I get a check for about £42. And it's still going, it's still running, because the cost bill was massive. And they must have negotiated the solicitors. So, you know, go for an instalment payment. I mean, it cheers me up when I get that check once a year. Yeah, and what we're going to look at now is, well, what if that's a dead end? That's run into the sand. Oops. So what we need to do is then to start thinking about enforcement. And I'm just going to go. That's okay. All right. That's it. Okay. And there's a number of areas particularly that I want us to look at, about mechanisms in which we can look at the landlord's goods, the wages and their salaries, their savings and their assets. So captured, set out within Practice Direction 70, the warrant of control in the county court. So that's a warrant, bailiff's warrant, done administratively, to the value of to £5,000, otherwise into the High Court, the writ of control. Attachment of earnings order, which we may have met through different routes, perhaps in the family court. Certainly a long time ago when I was a pupil, I was involved with a family verse 6 as it was then. And that was something that was very prominent and featured around the family courts. A third party debt order, this is really the savings. Okay, so bank accounts, I think that's probably the best way in to think about it. And a charging order, perhaps moving on to, as well, on the cusp of getting an order for sale. And I think that's the fruition, if you like, ultimately getting to that the end of that process and realising an order for sale. I'd be really interested to hear comments about that, people's experience of doing that. And does the mechanism smoke out the rabbit, so to speak, of the landlord paying up? Or how does the court even approach the consideration of an order for sale? So, for example, in the commentary around in the white book, it's saying, well, it's one thing to get a charging order, it's quite another to get an order for sale, but nevertheless it be done judicially and so on. So it's got to come down to that piece of case law at the end. Orders, you may get some simultaneous enforcement, so you could have a number of prongs at the assets, if you like. So a number of those can be used simultaneously or concurrently. But actually what I also just wanted to do, and it was interesting, just in, here we go again, right, is that the right one? Sorry, that's right. Wrong way. Say it a bit. Sorry.
Need a hand, are you okay?
Oh, no, fine. Like we're on closing speakers.
Finish.
Right. Sorry, Alex. I'm really sorry about that. I was going to blame it the fact I'm left-handed, which is why I'm sat on the left, but it's not. That's it. 71. Yeah.
Okay.
Great.
I'll just
okay.
say next slide, please.
Okay.
Perfect.
Yeah. All right. So 71, part 71, is to information. Okay, under the CPR, to gather information such that you can identify what's your best bet, to put it colloquially, so to speak. And that is a mechanism in which the court, you can apply to the court for a judgment debtor. So the judgment creditor is the tenant who has the judgment order against them for many thousands of pounds, for example, that we've been hearing about. And the judgment debtor required to attend court to provide information for the purposes of a judgment credit to enforce a judgment order against him. And the forms are all there within the CPR, within the pro formas, which distill the various information that then is set out on the pro forma. When the judgment was, the name and address, do you want a hearing in front of a judge, and documents to be produced. Okay, so this is a fertile mechanism in which to turn up information. And within the body of this, because we will talk about committal too later, but actually this is within the court rules, that if there's defiance or non-response, then there's mechanisms for an appeal notice that the court will put on to say you've got to come to court. The mechanism then can be referred to a High Court or a circuit judge. So even just with the courts doing that within its own rules, so pressure to bear, if you have a rogue landlord, to use that expression, then there is the pressure will come to bear. All of a sudden, you know, we have the rule of law, not rule of the mob. And it might be the first time that that's the realization has come to some of these characters that we're dealing with. I would suggest so. And then there will be there's various hoops that the applicant needs to go through, pay the travel expenses of the landlord to court, for example, affidavit of service of the order. But there will actually be a move to make a suspended committal at that juncture by the court. So next slide, thank you. Yes, warrant and written control. Okay, this I think bailiffs, there is a, we all understand what a bailiff is. I think looking at the oversight and the framework within the taking control of goods and regulations, for example, is interesting because it's blow by blow. You know, you're not allowed, the bailiff's not allowed to take a dining room table that's too small for enough people that live in the house to sit around. Okay, that type of thing. So just that, this is the bailiff's remit, but certainly detail about what can and cannot be taken. Now, you might have an idea about what your landlord has. Maybe it's the old footage of the unlawful eviction where you see the 4x4 driving up, you know, and the lock change on the CCTV. So, well, actually, let's have a look at that, and to go and to look and to see what may be realisable and sold by the bailiffs at value and so on and so forth. Once the landlord is in that process, then there may be an application to generally to suspend enforcement, paying by instalments, etc. So finally getting the horse to water through the court. The third party debt order, this is in relation to the savings as I was talking about, so bank accounts. So debt, if a judgment debtor is owed money by a third party, the judgment creditor can obtain an order by the third party should pay the judgment creditor. The third party is within the UK, as we'd heard Marie say earlier. When we're looking at the commentaries around this, you're often dealing with big companies moving assets out and what you do then. I think we're going to be focused here, but nevertheless, there it is. It has to be a third party within the UK. An application and an interim order, and then the court will decide whether to make a final order. We may have the information, we don't need to perhaps use 71 because we may have the bank account of the company or the landlord, landlady, because we're been paying rent. Okay, so we know that they've got a bank account, but then there's also implications about if it's a joint bank account, for example. So all joint account holders must be judgment debtors. So you can't just have one half of a spouse, for example, who isn't in its joint account. So it would have to be in the sole name. And there's also a mechanism for around a third party debt for hardship to be applied for by the landlord, who says that you can't just freeze that amount of money because I need for the ordinary daily living and so on and so forth. Attachment of earnings order onto the employer to amount specified in the court order and paid to the judgment creditor. You could actually research as a form to search the register to see whether any such orders have been made or on the register. Various procedural matters, but also again, if non-engagement with the process or reply, then there is the court can move to committal too. So that's quite interesting again. So we see it within the rules. So very serious in what the approach that the rules take, and the court may ultimately go. Consolidated attachment orders, there's several against an individual may be consolidated in relation to seeking one payment of one debt. On to charging orders, governed by CPR 73, imposing on such property of a judgment debtor as may be specified a charge for securing the payment or money due under an order. It's the charging order on land, which is the most commonly available. Again, forms to be used, application, interim, and then the making ultimately the final charging order. And also venue can be made. It can be made on notice, but can be through the civil national, will be through the civil national business centre unless it's been transferred. An interim charging order can be made without a hearing, so it can be done on the papers. But if then there's an objection, then there's directions and so on for the furnishing of evidence and grounds of objection to be filed. And then in terms of the general principles, it's a discretion. So classic English law, discretion or relevant circumstances. That's the next bit, isn't it? When we hear about discretion, the court's discretion, weighing up and so on, to be taken into consideration. So the history, the size of the debt is a factor. It's but one factor. It's not, doesn't weigh any heavily. It's in the balance with everything else. And also the interests of others. For example, what are the implications of this charging order? Are there other creditors unsecured? Who else lives there? For example, the burden is on the debtor about why a charging order would not be made at that stage, once you get to that stage, once the interim order has been made. In relation to the matrimonial home, if a land is the sole name of a judgment debtor or jointly by spouses who are both debtors, the order is against the land itself. If it's owned jointly by a judgment debtor and somebody else, for example, a spouse, then the order is made on that beneficial interest. That's all pretty basic, and the stuff that you'd see elsewhere in other jurisdictions around the family courts and so on, and probate, property, and so on and so forth. Needs to be serviced on anybody else who does have an interest in that property. And if there's already proceedings within a divorce court, for example, or civil partnerships, so dissolution of civil partnership, then the case can be referred to the family court alongside the other property orders. So on to enforcement of charging by sale. This is on CPR 73. The Part 8 procedure is to be used. Detailed evidence information is required, and the claimant must take all reasonable steps to obtain specified information. And the approach of the court in this case is set out. I think the commentary is useful in the White Book. So it's talking about the High Court case. I think it's Close versus Pyle, I think it's called. Is an old compatibility case. So is this compatible with the ECHR? Okay, yes it is, but and then it sets out all so like reasonableness, you know, the reasonableness test under the Housing Act is compatible. Okay, I know this is the basic stuff under Article 8, but nevertheless, weighing up matters, everything needs to be minded to the behaviour of conduct of a debtor, refusal, defiance, and so on. That would be a relevant factor into persuading a court to say, well, this person is just totally defiant of this court court and these orders, and it should be exercised in relation to that. But as I stated, the matter of a principle also stated is that the beneficiary of a debt that's owed, you can't be, that's a really important factor too, not to be able to get your money when a court has ordered that you're owed it. So that's going to be weighing very heavily alongside somebody saying, I need this property back now because I need to move it back in, or whatever it is. Okay, so everything on its facts, but remember where we are at this juncture within the proceedings, why we're there, why we're needing it. Enforcement of mandatory orders. I'm not going into this in any great detail, so the slides are just very brief, but CPR 81, as we know, we're usually on the other end of this, aren't we? And what we'll be looking at is, did they serve all the procedural, you know, is everything nailed on? We're trying to get in the way of this injunction to get someone to turn their music down that have been playing at 4 AM for the last 10 years, okay, and disturbing everybody else, to use an example. But trying to procedurally to make sure it has to be totally done properly. And again, all around notice, for example, without notice, and all of those important provisions. So you'd need to have to apply and make sure that you're complying with everything in relation procedurally to that, starting off under CPR 23, essential to ensure full compliance. And that includes the distilling, like we see in those injunctions, the ASBs, the particularisation of breach, when it was, and so on. All of that would need to be done. And I don't know, again, we need to have confirmation with the penal notice, but also we've heard a bit about Lambeth, haven't we, about the trouble Lambeth are in. And I think, is that to do, because I'm not in London, but is it to do with, it's to do with it's not just to do with this, is it? Or is the move to commit the chief exec, is it, or? I'm not sure.
There's loads.
They just don't comply with court orders
Where do we begin with Lambeth?
Yeah.
I'm just slightly aware of
Sorry,
the time.
yes, yeah, no, sure.
We can moan. I was about to use a stronger word about Lambeth over coffee in a second, but continue certainly with the.
Yeah, I think that okay. So in full compliance, we know what the sanctions are. So fine or imprisonment or both, suspended up to 2 years, as the law will allow. I think I'll stop there. Yeah. Okay.
Sorry to rush you, John. I know that we
No,
had
it's fine.
a lot of things to get through. Thanks, everyone. So we do have a break now before we can come back to do some questions and answer sessions, because I know there was a lot of content covered in this, and so we need to sort of process it. I just think this talk reminded me very vividly of a hearing where we got to the end and we got a quite large award against a landlord. And I remember her sitting there and saying out loud, but I can't meet that debt unless I have to sell my investment. I'm like, yes, love, and? But she couldn't, she kind of couldn't get into her head that she wasn't entitled to hold on to the property no matter what she had done.
Yeah.
So I would love to hear more stories of that kind of thing happening, because it made me feel good in my heart. Coffee break time. Great. Thanks, everyone. When is everyone back? Oh, wait, there's probably.
Hi, everybody. Sorry, man down. Alice has had to depart, not for anything bad. I think she's just doing some work. But I will be now chairing the Q&A. Whether there's not going to be a roving mic unless I move, so just shout. But I can provide a mic on request. So we just thought we'd have, because the idea of this session was to make it there's a bit of law, as you can see, but a bit more discursive, people sharing their practical experience of this, because I think that's the most important thing, really. We just do the skeletons and the rest of it, but you guys are actually doing the practice and trying to nail these landlords down. So it's an information sharing session, really. But to start, does anybody have any questions for me or John or Cara or Will? And Harrod, may you shout. Yeah.
This is more of a thought, because I've actually not done that much in eviction. But the issue with kind of getting expert evidence for section 57 damages, it's a bit of an expense to go to when so much uncertainty is that, first of all, whether you're going to be relying on that at the end, because you might end up going for the other damages, you won't always know until at the end of the case. But also, you don't even know if you're going to win, and it's only relevant to quantum. One of the things that I thought, I wonder whether anyone's ever tried to do a split trial in the direction, so that you basically have liability dealt with, and then quantum is relevant, then adjourned to a different date, so that you can then, at that point, if the landlord already knows that, there's being judgment in tenant's favour, that you can then get possibly joint evidence on quantum. I mean, what are people's experiences of getting this? So I personally never got surveyor evidence for section 37. So it'd be interesting to know.
Question for Cara, I think.
I haven't had anything that's been done as a split trial, but I can see the obvious merit in doing that. I think it's, while I sort of expressed that it's expensive in terms of you can't get the legal aid rates, it's not horrifically expensive. I think it's a justifiable disbursement that you would be able to claim. So while it's in excess of the legal aid rates, it's not a ginormous cost, and so I do think you can get it at an early stage, and it's obviously useful in terms of like settlement and things like that. So I think that's part of the justification of having it earlier.
Yeah, I think Sarah could contribute.
Really like to go to split trials unless there's a really obvious justification for it. In my experience, most unlawful eviction cases are legally really straightforward on liability, and in fact, I can't think of a case where I haven't had summary judgment or a strikeout defense. So, yeah, if you really had a genuinely sort of could go either way case, I can see why you might want to defer getting valuation evidence. I can't say I've had one. They're just normally.
Yeah, they're normally really clear cut. And if you're legally aided, especially, I think you'll be quite confident in getting the valuation evidence, because for legal aid damages only claims, so because obviously you can only get section 27 damages if your client's not reinstated, then you're in cost benefit territory, and that's obviously affected by the level of prospects. So when I was working with Sarah as a pupil, we often would assess prospects are very good, 80%, at which point you're, because they're so clear cut, at which point the costs, the benefit only needs to exceed the costs. And so you're sort of justified in, you can be quite confident in getting your valuation evidence.
That's quite a good one for council, isn't it? Because they never give you merits that are more than like, if it's more than 70%, you're like, what? But for that, there's that bit in the merits regs.
Yeah,
you just say it's like 90%.
Normally I'm like 60.
Yeah.
I'm sure. The other thing is, I think in my experience anyways, the cases where it's the merits on liability are a bit shaky are the ones where you're not going to get section 27 damages anyway. So like if the classic one is, they're not actually an assured shut-hold tenant because I lived in the house or whatever, they probably had quite limited, even at your highest end of the case, like your case at its highest, they probably don't have that much security of tenure anyway. Otherwise, give it a go. I have to say, Sarah, I think, has much more experience in section 27 and section 28 cases than I do. But if it's like a local authority, why not?
Yeah, they're in the whole block of flats.
That's particularly funny. I don't think.
Exciting times.
Sally, have you got a question? Anybody? No? No.
and doing it was more difficult.
Really?
Um,
And finding 3 of them to give to the legal aid agency. Or were they happy? That's really good.
It's hard to find, and they definitely don't work for £40 an hour. They're all like, it's £300 an hour, or like a bit less, but like, yeah, they want lots of money, because what they're normally doing is not legal aid cases, in my experience. Like,
Oh yeah, their value
valuation.
housing.
Yeah, it's like, yeah. So,
That's why you need to set everything out that I said
Yeah.
in the instruction letter so they actually do what they need to do.
Any other questions? Oh yeah.
I think the two-part question. One is about whether anyone has experience in getting legal aid to cover the costs of an investigator. Well, I'm certainly not. I've just been doing my own investigation, which is probably quite challenging.
yeah, I have, although I just sort of went a bit gung-ho on it and just did it, and then thought I'd be fine, I'll win this case and get the costs back. And I did, so I didn't ever have to like justify it. So it's fine. But I think because there's not like a rate specified for it, so I think probably the like technically best approach would be probably to get prior authority for it. But I can't see why you couldn't get it. If it's like I just need more evidence into who this website is, and I can't get further than the website, and it's like critical to your case, I would have thought you should get prior authority. But yeah. Although the legal aid agency are funny with prior authority. Depends who you get.
Yeah.
Yeah, the decision making.
Questions? Views? Oh, again.
That's 2.
Yeah.
Oh, sorry.
Yeah. Unrelated. But sometimes what we're finding is that a landlord owns the property that they have rented to the tenant.
Yeah.
But they don't have any other assets in their name. So if we want to get a charge order, it would be against the property the client's living in. But if we try and go for an order of sale, there's going to be lots of issues. Well, we're going to have to sell it with a sitting tenant, if we don't have a duty of case that's not applied.
Yeah, but you're not going to evict your client, or are you? Yeah.
Seems like it's
Yeah, no, I can't say if I've ever had to do that. I would have thought there wasn't like any obvious reason why you couldn't sell it subject to depending on the type of tenancy, or why you couldn't sell it subject to the tenancy, which obviously you would do in that situation. You're still going to be worth a lot of money, even with the tenant in it, probably a lot more than your damages and costs. So I would imagine you'd be okay. I don't think. I'm just trying to give you that. Maybe you get like a different department in your firm to do the conveyancing or something, or yeah.
Yeah, I mean it's tricky, I suppose. I mean, if it's damages rather than costs that you're after, I mean, it would be in the tenant's name, and they become their own landlord.
Yeah.
I know it's very complicated. But yeah, I don't think. Yeah, I guess that's a situation where you might want to think about all the other steps you can do before you go for an order for sale, which I'm sure you already know. Emma?
In terms of if you've got a really meaty eviction, well, I mean, general damage that I can't pretty much, but if say secure tenants evicted, or you have a lot of specials, and you're worried about dissipation of assets, in terms of like what I guess we should be considering freezing orders, but how do you get around the cost of damages in those circumstances? And I guess if you can identify the assets they do have, how regularly should you be checking in? And when, because you can't have a freezing order unless you've got a dissipation. And but by the time it dissipates,
I think I've only had one experience of it, and it was a disaster. It was a disaster. So I think it was actually a case where it settled partially on the basis that they were going to pay us, and partially on the basis that they were going to grant a new tenancy to the tenant, and then they immediately sold it before they signed it. There was something very sneaky. They tried to sell it before, so we did actually get a freezing injunction to stop the sale, but remember what happened in the end. But yeah, it was, it's very difficult. I think, and we didn't have to give a cost undertaking, but I think it was just because it was so obvious what they were doing. I think you'd struggle with the legal aid argument if you, you can try. But you'd have to have very strong evidence that they're about to dissipate their assets, I think. In my case, they kept on saying, we're not selling it, and then it was on Rightmove.
Yeah.
So the judge wasn't really worried about too much else. Yeah.
I think I've had one as well, like what I'd call like a good son, bad son case. So like I think I had a little old lady whose son had tricked her into transferring the property into his name, and then was trying to sell the house because he had loads of debts. And we managed to get a freezing order to stop that sale. And yeah, they didn't care about the fact that we had no money at all on legal aid. It just was like, we had quite a lot of evidence.
Yeah.
It was like, yeah, like some estate agents turned up and tried to sell the property. And then I didn't think I needed to then check on their assets at that point because we got our freezing order.
Yeah.
And then it was kind of like, then there was litigation and everything was sort of stayed pending that. But yeah.
Thoughts, experiences, questions, anybody? Hi, Alex. Yeah.
Yeah.
There's a case law on that, I think, in a commercial shipping case. Dating back to 2002. Essentially, the director can be personally liable as a tortfeasor for acts they do. And I just wonder, in terms of enforcement then, because I think Will mentioned that he's got judgments against an individual and the company. Can you then go after the director personally? And I suppose that will put more.
Yeah, I think it's not my case, but I think that's what they're doing in that case. I think he'd been involved in the unlawful eviction stuff as well as being the director of this company. But yeah, I'm not sure of all of the background facts to it, but yeah. Yeah.
Very good point. Emma.
Any authority that would apply that to an liability part? I've got a landlord now, and I'm unsure whether it can be applied by an additional but I'm not had any direct authority, but I've accepted that
I have no idea, but I will look into it.
I also have no idea.
Thanks. With company directors, is it the claim itself, isn't it? You list it as a defendant in the claim, and both, and then when you're employed. Any more for any more? We're going to move on to.
I have a question for Will and John, but it's you're looking horrified.
You don't know that.
It's kind of an excuse to tell you about the most horrific case that I've come across. So the question is whether or not either of you have any experience of finding out about offshore companies, and if there is any mechanism for finding out who directors are and things like that. And the context is a case in which a Isle of Man-based company, which was the claimant to a possession claim and a counterclaim for harassment, and the claimant was, I think it is probably fair to say, some sort of mafia organisation, or definitely like high-level organised crime. At least they were renting my client's very small flat to her at £4,000 a week, and she was a prostitute. One would think that the rent was in fact pimping income. And they put a brick through her window and I couldn't hear it. So, and they haven't paid us our costs, which is, of course, the least of anyone's problems. But it would be good to get them.
Yeah.
Really.
I wonder if there's a parallel for somebody said, didn't they? What was it called? Find, was it? Yeah. So is there a parallel one of those for the nefarious end of business and offshore. Yeah, there must be, mustn't there, in the commercial courts? There must be those mechanisms there, but I don't know what they are. But there will be, surely, won't there? I think.
I think you're gonna have to find out, Sarah, and tell us. Yeah.
Is that the one that was on the Panama Papers?
Oh, yes.
Yeah, no, I've never had to enforce against like a company, like a non-UK based company. Yeah, yeah.
Any other questions? Anybody enforced against the mafia?
Anyone work for the mafia? Perhaps you can help.
Yeah. You know, absent of what we were talking about this morning about getting the police to take action, do you mean like sort of taking a private prosecution? So do you mean without the help of the police, whether they can make a private prosecution?
Either.
Okay, I think I'm not an expert on private prosecutions, and I'll be corrected, but I think that would be extraordinarily difficult on their own and risky. Yeah, that's not going to happen. So I think the best thing you can do is if you say that the police refuse to help you at some point before, now that you've got hopefully a written judgment or at least a note of the judgment, and you've got something more supportive. It's not like when you know, oftentimes you go to the police when just in the heat of the moment once it's just happened, and you heard from John, sometimes the police join in. So that's a very different picture if you go to them now with that behind you. But you know, again, I think in the context of what we've heard today, and Sarah can maybe talk to us more about it, but they probably aren't going to be that motivated to do it in circumstances where it's been some time ago, which is not how police should investigate. So you know, they may if you present more evidence to them and they still refuse to investigate, or they refuse to consider to investigate, then that might strengthen any sort of challenge you bring. But yeah, it would be difficult, I think.
So either continue to press them on, or private prosecution, which is not really.
I think I can't advise on private prosecutions, but from my understanding, pedestrian understanding, I think it would be extraordinarily difficult. But yeah, the best thing is really just trying again with the police and the local authority. Yeah, it's unfair. Hi.
Sorry to butt in again. In a witness statement that the managing agent put in, which was unhinged, and in which he claims to not have discriminated against our client, because he is a practitioner of discrimination.
He's an expert discriminating. He's got a certificate and everything.
Sure.
Yeah, I do this shit for a living.
Reference being interviewed by the police after attending our client's house and intimidating them. You didn't have to disclose.
Above and beyond.
Yeah, so my thinking now is, oh, well, the police's report or whatever paperwork is with the police will be relevant. He might not have sight of it, but obviously we can try and get a hold of it from the police. And I think there's a mechanism by which you can ask about someone's records with the police if you've got a justifiable reason. I wonder if anyone's got any experience on that.
I think I've not got any experience of it. Did your client call the police?
Yeah.
Okay, so maybe they'd probably be able
Ask
to.
for their
ask for their
records.
records.
Yeah.
Yeah, and then the police did attend, and while the landlord did an inspection, threatened his kids, and then.
I think the way you do it is through asking for your client's records.
Yeah.
And Sarah.
I can help that.
Yeah.
So there's a provision in the Data Protection Act which allows them to disclose those documents on a voluntary basis, but the threshold is quite high because they have to be necessary for the purposes of the legal proceedings. So it is quite a high threshold, and even then, it's only permissive. So it gives the police the power to give the private documents to you, but they don't have to. So usually you have to start by writing to them saying, we would like these, we think you can disclose them, here's why we say they're necessary. But almost certainly the police will
Say no.
get an order and you have to get it.
If it's anything like disclosure from local authorities, it would be awful, and they'll just redact everything. I feel like now medical people being redacted their names recently. I was like,
They keep on doing that. They're not allowed to do
No,
it.
no.
They need to get an order if they
I
want
can imagine the police probably similar. But yeah, definitely worth getting your client's own
Oh, definitely.
criminal
Yeah.
record, though. Oh, not criminal record, records.
This is a
Yeah.
practitioner. Hi.
Just on enforcement, I just wondered whether these third party debtors, we use one of the land paid up very quickly.
Really?
Tenants have the bank account where the rent is being paid. Not a huge amount of money, maybe. This was about 6,000. And as soon as the landlord got the interim order, he paid up straight away because he was so embarrassed to bank contact. So,
That's a success story. I think
it's quite quick.
yeah, I think the only note of caution is what John was saying earlier about joint bank accounts. But other than that, yeah.
Yeah.
But that's brilliant. I've got no experience of it myself, but that sounds like a good way of doing it. And you found a landlord that has shame. That's good. I think it's time to move on to our closing speeches, unless there's any urgent questions. You can also come and get us later on. So that is going to be from Sarah, our head of housing, and then Martin Westgate, KC afterwards, who is, okay, maybe it's Sarah at the minute. No, Martin's there. So it's going to be Sarah first, speaking to us about rogue landlords and the future of AI. And then after that, we're going to get a closing speech from Martin. I'm going to swap over.
Yeah.
Mike, yes, this.
You want to press the button?
Okay, better. Oh, excellent. All right, so before Martin Westgate wraps up the conference, I have an opportunity to look at something just a little bit different. We've had a lot of practical tips and advice and opportunities to ask questions. What I'm going to do is think forward as to how issues in relation to rogue landlords or criminal landlords, to use Dr. Rugg's terminology, might come up and be addressed in the future. So obviously the big issue on the horizon is the Renters' Rights Bill, and Martin's going to pick up some of the issues that arise from that in a moment. And of course, you've heard from lots of the speakers today about what the Renters' Rights Bill has got in it. But I am going to look briefly at the advent and development of AI and how that might affect landlord harassment and what we can do about it. So it's a little bit of a think piece. Now, I have to say, I am a complete novice when it comes to this. I use ChatGPT to plan my holiday itinerary, but that's about it. But what's really obvious is that the pace of AI is really, really fast. It's taking over astonishingly quickly. I did buy a tumble dryer recently, and I just wanted a tumble dryer that you turn the dial on and then it would heat the clothes for that amount of time. You cannot buy that anymore. It is not possible. The cheapest tumble dryer that I could buy still senses how wet my clothes are and what clothes I've put in the tumble dryer, and then dries them for just long enough to get them so that they're still damp, and then sends me a text message to tell me that it's dried my clothes. And isn't it clever? So it doesn't work very well, but it does have AI in it. So the point is that AI is becoming inescapable. And apart from panicking about the coming robot apocalypse, it is something that we need to start thinking about. So, as I say, I don't know anything about it, but Matthew Lee in Chambers, he does know about this stuff, and unfortunately he couldn't be here today. So he has given me some things to say to you, and I am going to channel Matt through me to you as he ponders about what those issues are. So let's hear what Matt has to say, basically. So first of all, excessive monitoring. So rogue landlords already use various forms of surveillance. I've got a case at the moment where the landlord put a tracker device on my client's car, employed 3 surveillance operatives to provide round-the-clock surveillance, and have been trawling through his social media and so on to identify close family members. They've obtained his marriage certificate, his birth certificate, and so on. You can see that AI dramatically escalates this threat. So it enables landlords to not only record tenants' activities, but also to analyse those activities. So they can use facial recognition software, which is getting cheaper and cheaper, and they can provide algorithms to assess that. So, for example, an AI-enabled camera in the communal parts of a building might be able to say when your client went in and out of the building, or what visitors they had, or at what hours their visitors arrived. They might instantly notify a landlord when a tenant returns late. They might be able to provide schedules of your client's movements. So tenants can resist this in a number of ways, clearly asserting their privacy rights under the GDPR, under Article 8, under the Equality Act sometimes, and ensuring that surveillance measures are set out in tenancy agreements as to be limited. And it's worth remembering that, of course, you can claim damages for breach of the Data Protection Act. And there is an interesting case which you may not have come across, but it's really worth looking up, especially for rent arrears cases, of Becco and the London Borough of Islington. It's a High Court case from 2023. And that was a possession case in which actually it wasn't a possession case, but it was in the context of possession proceedings, where the tenant had made a subject access request of his landlord, and he brought a DPA claim for distress under Section 168, and he got £6,000 in damages. £6,000 in damages. And if you think of how many cases we do where there is something like that, you can see how it is not a sum of money to be sniffed at. There's also the new common law tort, I say new, it's probably not that new to me, of misuse of private information, which is, as I say, a common law tort in relation to data. Second, automated complaint denial. So landlords frequently ignore tenant complaints, but AI transforms this into a systemic issue. So landlords can use AI chatbots or automated complaint systems to automatically dismiss or trivialise or mislabel complaints that tenants make. These use large language models to deflect genuine maintenance concerns by labelling them as minor or labelling them as complete. How often do we see schedules of repairs where it just says complete, complete, complete? Is that automated? Well, it's difficult for us to know, but certainly something on the horizon that they may well be automated if they are not already. Tenants can mitigate this by demanding human verification and clearly documenting all maintenance requests in writing by themselves. I always say to clients, use email, use WhatsApp, make sure that you've got a record of the time, record of what was said. I'm a big fan for clients that find it difficult to write of using voice notes. It's a really obvious, reasonable adjustment that you can ask for if you've got a client that's got any sort of communication difficulties. I'd like a mobile phone number that I can communicate with, and when I've got an issue, I can send a voice note from my phone. Easy to do. Third, personalised harassment. Obviously, harassment of tenants is nothing new, but AI dramatically amplifies the personalisation and scale. So using large language models, landlords can automatically generate targeted or persistent harassment messages tailored specifically to tenants' personal situations. Now, Matt speculates that this might include targeting to tenants' emotional vulnerabilities. That might be a bit extreme, but here's something that we can all imagine happening. Automated messages when there are rent arrears. really regular automated messages saying pay up, pay up, pay up, pay up, pay up, pay up. And you can easily see how stressful and distressing that could be. And of course, don't forget, we've got the case of Worthington and Metropolitan Housing Association, which I think you heard about earlier, and how demands for payment, demands for in relation to legal proceedings can amount to harassment. Fourth, predictive neglect. While landlords neglecting repairs and maintenance is more common than it should be, AI introduces predictive analytics that can allow neglect to become strategic and targeted. Landlords might use AI to predict exactly how long tenants will tolerate unresolved issues, calculating precisely when a tenant is likely to move out rather than pursue further action. For example, AI might predict that a tenant is unlikely to leave within 6 months, even if repairs like heating or plumbing remain unfixed, thus incentivizing strategic delays by the landlord. Again, tenants must keep records, keep consistent, ensure that their data is protected. Next, AI-driven rents and charges. Now, this already happens. You may not have come across it because it's not something that has yet been subject to litigation, so far as I'm aware. But dynamic pricing of rents is something that happens. And certainly in America and Canada, there have been cases that have looked at exactly this. So quite obviously, the market is going to make rents higher in situations where demand is higher. But what if that algorithm also relates to your client's individual circumstances? What if there is something about their characteristics that might mean that they are going to find it harder to find accommodation? What if AI is used to say, well, a person who has a history of depression, let's say, is more likely to get into rent arrears, so we should charge more in rent to try and protect ourselves from that position, from that situation. So again, that is the sort of thing where we might see AI being a tool for the less legit landlords. And that also obviously relates to things like credit and background profiling. So using AI to analyse whether, based on your social media content, your employment history, your medical records, anything else that might be found online that a large language model can be used to access, whether or not that makes you a more or less desirable tenant, whether that affects the way that you are treated, whether or not there are more reminders, more insistence, less tolerance of arrears, whatever it is. It really makes the whole idea of sort of no DSS benefits discrimination seem slightly pedestrian by comparison, because what we can imagine is a much more complex, much more sophisticated, but even more invasive form of discrimination. Finally, automated eviction notices. Again, similar to the rent reminders. We've all had landlords who have had a sort of, you're in arrears, here's your notice kind of approach. But again, it makes it a lot easier for those sorts of landlords. Similar in relation to other sorts of legal threats. Matt also talks about tenant data monetization. And this is only obviously going to, and I caveat this by saying this is a think piece. But the bigger landlords have a lot of data on their tenants, and that data is valuable. And it isn't so very far-fetched to think that that might be data that could be monetized for marketing purposes or for some other purposes. And obviously, selling data in this way is obviously a Data Protection Act breach. It's obviously something that you could potentially bring a claim over. But I also think it relates back to something really fundamental about all of this, which is that when you use AI to generate a document, I'm sure you all know this, you have to put in the data, obviously. You have to put in the information about that particular client, confidential information, data that they have ownership of. And that in itself is a Data Protection Act breach. That in itself is a GDPR breach. And I don't know whether Dan is still here, but if you get an opportunity to ask Dan about some of the letters that have been coming from some London local authorities, which have invented cases and strongly appear to have been created by ChatGPT, that obviously that brings out that question of, in order to generate those letters saying, no, your disrepair claim is only worth X because of these imaginary cases that I'm citing. In order to do that, your client's data has been put into that system, that unsecure system, and it's presented then by a legal professional as if that was a document which is a properly considered legal document. So these things are happening. And as I say, unless we just sort of cry about the coming robot apocalypse, it is something that we need to at least start thinking about. And maybe it's something that we need to think about for our own benefit, as well as defending against the future rogue landlords. Right. Okay.
Well, thank you, Sarah, for that food for thought. My role here is rather grandly described as a closing speech. And I only want to make a few points and then make some observations about the enforcement provisions in particular in the Renters Reform Renters' Rights Bill. This is I've forgotten how many, but it's the latest in a series of annual conferences on housing topics that we've run. And this year we've taken a slightly different tack because in the past what we've tended to do is look at a very broad area, whereas here we've focused on what, when you read the flyer to begin with, seemed like a fairly self-contained topic. But it reveals the truism that the closer you look at pretty much anything, the more there is in it. And so there's so much here that's connected that we've had an opportunity to talk about today. Different kinds of criminal liability, how criminality is fostered by some rogue landlord arrangements, the relationship between criminal law, public law and enforcement, tortious claims, contractual claims, and so on, across the entire board, which, again, you tend not to have routinely. It means that we've had to discuss how to deal with people who are sufficiently well-resourced to try and put their assets beyond enforcement. And so we've had to look at the kind of things that are normally the reserve of oligarchs and those who act for and against them. And also what's happened is I find what I find every year on these things. I come to something where I thought I knew the area fairly well, and I leave pretty much with my head spinning with all the things I didn't know and I need to go and educate myself about. Obviously, we had a huge amount of detail and practical advice, but if there is a theme, it's one which is perhaps an attitude of frustration in some ways, in a good way, because it's concerns about the effectiveness of enforcement in various ways. There's a lax attitude by the authorities where criminals get off, in simple terms. And the statistics were telling in one of the earlier talks about the larger number of rent repayment orders applied for than local authority enforcement. And what that perhaps shows is that hitting landlords in their pocket is more effective sometimes than other types of enforcement. So monetary remedies are genuinely dissuasive. And secondly, that private action may be more effective than public action. But the sad truth is that's only because the public authorities are as relaxed about it as they are in deciding whether or not to pursue landlords. And in any event, what it does is it puts the burden on the tenants to take action when they've had to, or may have had to endure so much already. And it means that they run the risk of winning a great civil victory, but finding that it goes unmet because of enforcement. And so it's against that background, really, that I want to make some observations about the Renters' Rights Bill, and whether that's going to be a game changer, which it could be in some respects, in particular duty to enforce. And it's worth looking at that in a little detail. Before I do that, there's obviously the headline point, that it abolishes assured short-hold tenancies, hurrah. But one wonders what the consequences of that may be. It means that in many respects, the stakes are higher for a landlord. Are they then going to be more encouraged to pursue unlawful eviction, or are we also going to see the kind of avoidance behaviours that we had many, many years ago under the Rent Acts? Are we going to have sham licenses? Are we going to have more sham holiday lettings, more sham company lettings? I was surprised to hear from Sarah that there are already quite a lot of company lettings out there. But we may see a proliferation of that sort of thing. So we may have to add to our toolkit, in addition to all the enforcement stuff we have to learn about and so on, to learn about shams again. But the question on that I want to address is how far the Renters' Rights Bill might provide some remedies to the kind of things that we've been talking about today, and in particular, the enforcement duty, and unfortunately I haven't got a slide on this, but it's going to be in what's currently clause 107 of the bill. The bill is in the House of Lords at the moment. It went on in January and is probably going to run through sometime in the middle of this year. But what that says is clause 107.1, if it is enacted in this form, will say it is the duty of every local housing authority to enforce the landlord legislation in its area. So that's pretty stark. What is the landlord legislation? It's sections 1 and 1A of the Protection from Eviction Act. We've been talking about that a lot today. Chapters 3 and 6 of part 1 of the Renters' Rights Act and part 2 of that act. I'll tell you a little bit about what those are. And chapter 1 of part 1 of the 1988 Act, the Housing Act. What's that got to do with enforcement, you might ask? Well, there are quite a lot of other provisions that are being put into that act by the bill. And so to start with those ones, there's going to be a new range of duties inserted into the Housing Act, including things like duties to give a statement of terms, and also prohibiting landlords from certain acts in what will be section 16E. And those are things like, or they include things like, purporting to end a tenancy by notice to quit. So if there is a sham and you pretend to serve a notice to quit and say, right, that brings it to an end, then that isn't just bad law. It'll be a breach of section 16E and will be subject to a financial penalty and in some circumstances offences. So that's that provision. What's in chapter 3, of part 1, that protects against discriminatory letting practices on the grounds of children or benefit status. So that may be, in part, a solution to some of the points that Sarah was talking about, some of the points we've been discussing. Chapter 6 prevents rent bidding, and the idea is you have to have a fixed rent on advertising something, and mustn't invite, encourage, or accept a higher offer. And again, that may be something that will assist in addressing the sort of concerns about dynamic charging that Sarah was talking about. It's not going to be a complete solution, but it might help at the outset and the initial letting. And curiously enough, it may be a case where that the boot is on the other foot with AI. If you want to know how that property was let in the past and what rents were charged and so on, then get onto your large language model. Provided, of course, you don't end up using information that should never have been on the large language model. And again, there's a financial penalty for that. And then the part 2, which is one of the other ones, is landlord redress schemes. There may be regulations making landlords join those, and landlord's database. And it'll be an offence if you let something if you're not on it, or rather a breach if you let it and it's not on it, and financial penalties again apply to that. So that's the range of sort of things that are going to be covered. And then the next question is, well, what's enforcement? And there things get perhaps a little more or a little less helpful, because the 1076 says, oh, sorry, that's it always would have to be me, wouldn't it? Our reference is to imposing a financial penalty and instituting proceedings against a person for an offence under the landlord legislation. So that's quite a lot of the things that we've been complaining about that they don't do. And again, if you read it together with subsection 1, it's a duty to do that. But what it doesn't do is help to address the kinds of things that we've also been talking about, which is where the police turn up or enforcement officers turn up and just let an eviction happen. No prosecution needed there, it's just happened anyway. And interestingly, what it doesn't do is make any reference to the police. There are obligations on local authorities to cooperate, but not to coordinate that with the police. And so the crunch question on this is going to be, well, what does the duty mean? Because we know the kind of arguments that local authorities are going to run. They're going to say, well, Parliament uses terms like duties, and they're big words, and you have to think carefully about what they really mean. Sometimes there are duties that require things to be done, duties. Other times, well, they mean target duties, and that sort of. And so are they going to be saying it's that sort of duty? So it's not really enforceable at all. I think if it goes through in this form, then that's going to be a difficult argument for them. It's a duty that seems to be directed to enforcement in individual cases of individual breaches. And I think the giveaway on that is that there's a provision that says that if another authority says they're going to prosecute in a particular case, then the duty doesn't apply to the authority in that case. And that must mean it's talking about individual breaches. Obviously, they've got to be satisfied that the actions happened, but it's not clear whether it really means, as it seems to, that they've got to do something in every case. But in fact, if you think about that, given that action can be a fine or prosecution, and given that in most cases they have a choice between whether they go for a fine or prosecution, or they may just be allowed to fine, then it may not actually be that onerous for a local authority to have to do that in every case. So what if they say, as they often do, well, we'd love to, but it can't be proved? Well, as far as fines are concerned, that's a matter for the local authority. So they can't really avoid it by saying, oh, well, we can't prove it, because if they think it happened, then they've got the power to fine. You're subject, obviously, to challenge on that. And for criminal cases, how do we address, or is there any more that can be said to help addressing a case where the local authority says, well, they can't be satisfied the crime will be proved? There's nothing direct in the Act about it. And obviously, Gus Silverman had some interesting things to say about the positive duties, in particular Article 8 and Article 3, and whether we can say that those impose an investigative duty. But it's also right that Chapter 3 of Part 2 has a whole raft of sections about information gathering powers, including powers to investigate and seize documents and so on. Now, those aren't in themselves enforcement within section 106, 107, but they are the sort of things that one might expect them to do. And if you're asking what reasonably could they have done under Article 8, then look at those provisions. What if they say, well, we haven't got any money? Well, the straightforward answer to that is, well, hard luck, it's a duty. And depending, of course, on what duty means. Also, there's a helpful provision in Schedule 5 that says that where a local housing authority imposes a financial penalty under various provisions, it may apply the proceeds towards meeting the costs and expenses incurred in or associated with carrying out any of its enforcement functions under this Act, or otherwise unrelated to the private rented sector. So it's actually a win-win for them because they can use the money to recycle it for the same powers. If they've got anything left over, they have to give it to the Secretary of State, but it's an answer to the point, well, we haven't got any money. So what can we expect to see? Hopefully, we'll see authorities stepping up to their duty and enforcing in appropriate cases, but it does look like we're going to see a lot more fines and prosecution. So that's all I wanted to say about the Act. And unless there's anything else that anyone wants to raise now, it only reminds me to thank various people. I'm not going to name anyone because it's unfair to do so, but the organisers who put in a terrific amount of work on this, and all the speakers who've given up their time to prepare some truly excellent talks. And the support staff here at Doughty Street who've made sure it all runs smoothly, which I hope you agree it has done. And of course you, who have turned up, stayed the course, and contributed throughout the day with some really insightful questions and contributions. And so thank you very much. And I'm afraid all we can do to reward you for your diligence and your attendance is to offer you a few drinks. And I hope you will remain afterwards to take advantage of that. But thank you very much, everyone.